and so it makes sense for us to get started. Welcome to the Joint Standing Committee on Health Coverage, Insurance, and Financial Services. We've got some public hearings this morning and some work sessions likely this afternoon. And so we will begin with committee introductions, starting with Representative Evans.
Thank you, Madam Chair. Good morning, everyone. I am Representative Richard Evans for House District 120, including the towns of Atkinson, Brownville, Dover Foxcroft, Medford, Milo, and Lakeview Plantation and Orneville Township.
Thank you. Representative Arford.
I'm Representative Poppy Arford. I represent District 49, which is the western half of Brunswick.
Representative Matheson.
Good morning, everybody. My name is Christy Matheson. I'm Representative District 1, Kittery.
Representative Blyer.
Thank you, Madam Chair. My name is Representative Mark Blyer. I represent District 22, which is Leamington and part of Buxton, Standish, and Limerick.
Representative Melrano.
Good morning, everyone. My name is Gina Melrano. I represent House District 62, which is part of Auburn.
Representative Brooks.
Good morning. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent the towns of Turner, Leeds, and Livermore, House District 75.
And Senator Brenner.
Good morning, Madam Chair. My name is Stacey Brenner. I represent Senate District 30, which is all of Gorham, most of Scarborough, and part of Buxton.
And Representative Tepler.
Good morning, everyone. I am Denise Tepler, and I represent House District number 54, which is all of the town of Topsham, and I serve as co-chair of the committee.
Excellent. And I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And we are assisted today by our incredible clerk, Christian Ritchie, and by our wonderful analyst, Colleen McCarthy-Reed. And so our plan for our first hearing this morning is that we are going to have a combined hearing on LD 167 and LD 367, as they are identical bills. And so in a normal time, they would have been combined, I think, by the revisor's office. In any case, so how I'm going to proceed with that is I'm going to ask the sponsors, Senator Claxton first to present the bill, and then Senator Pouliot to present his bill. And then we will open up for testimony in support, in opposition, and neither for nor against. So with that, I will invite Senator Claxton to kick us off this morning. Go ahead, Senator Claxton.
Thank you, Senator Sanborn, Representative Tepler, and honorable members of the Joint Standing Committee on Health Coverage, Insurance, and Financial Services. I am Ned Claxton, Senate from District 20, and serve the folks in Auburn, New Gloucester, Poland, Mechanic Falls, and Minot. I'm here to introduce LD 367, which is an act to require timely billing for healthcare services. And for the record, my duplicate bill is the better of the two. As consumers, we're expected to pay our bills on time. It's just a part of life that we all accept. We do our best to plan ahead, put money aside, and stay on top of dates and deadlines. But if you have no idea when a bill is going to arrive on your doorstep, how can you possibly plan ahead? Unfortunately, this is the reality that my constituents and I have faced with medical bills. That's why I introduced LD 367, which would prohibit a healthcare provider or facility from charging you for a service if they fail to bill you within 6 months of the service. This provision was originally part of LD 2111 in the 129th. I sponsored that last year, but we stripped that out to pass the other 3 portions of that bill. I'm hopeful that we can pass it into law now, since I still believe it's a critical step to take. We all know people who are struggling to pay their medical bills. These bills can be huge expenses that require financial planning and can threaten bankruptcy. To be surprised by a bill months and months after the fact is unacceptable. I myself experienced this when I received a $600 bill 7 months after the service. Folks are already facing an uncertain future as it is, doing their best to take care of their families, planning for future expenses, and preparing for unexpected circumstances. The last thing anyone needs these days is a surprise medical bill 6 months, a year, or even longer after they went to see the doctor or to the hospital. If Mainers are expected to pay their medical bills in a timely manner, the same expectation should be set for the companies doing the billing. Thank you for your time, and I welcome any questions you might have.
Thank you, Senator Claxton. Are there questions for Senator Claxton? Representative Morris.
Yes, thank you for being here, Senator Claxton. I know in your bill, because I also know about you, you are also a doctor, very well respected doctor, I would add, in the area. And we've gotten some testimony from providers around some of the issues with insurance. So I wonder if, as a doctor, if you could touch on that issue and what they have brought up as potential issues with insurance companies not telling them what they're going to pay for patients, and that's what some of the delay is.
Thank you, and it's an important part to consider in this legislation. As somebody who was in private practice or somebody who runs an organization without multiple layers of health insurance coverage, it only makes sense to get the bills out the door as soon as possible. Where you run into trouble is with larger bills and multiple different payers involved. What I'm looking for really is some way to indicate to the patient that a bill has been sent or is due, and that we don't know what the status is. I'm not looking for the final figure that you're going to get at the end of the pipeline after the copays, the deductibles, the adjustments, payment by insurance company A and payment by insurance company B, and what your portion is. I'm just looking to make sure that the patient knows that there's a bill out there that's looming if they can't take care of it right at the time, and they won't know what that final number is until later. So I think it's more as much an educational addition to the bills that go out as it is a separate bill.
Representative Morris, did you have a follow-up?
No, I just want to thank him for the clarification on that.
Okay, great. Representative Matheson, I saw your hand go up briefly. You're all set. Okay. So seeing no further questions, we will turn to Senator Pouliot.
Thank you for this opportunity.
Thank you, Senator Claxton.
Good morning, Senator Sanborn, Representative Tepler, members of the Joint Standing Committee on Health Coverage, Insurance, and Financial Services. I'm State Senator Matt Pouliot, and I represent Senate District 15, which are the towns of Augusta, China, Oakland, Sydney, and Bassaboro. And I'm here to present LD 167, an act to limit late medical billing to 6 months. I would like to point out that I did get my bill request in a timely fashion. The LD number is 167, which is 200 LDs before Senator Claxton's bill. So clearly the better of the two bills. But now slightly different, which you'll hear about in a moment. I was contacted by a constituent about this issue, who I'm hoping will be here today, though I can't verify if she is here or not. In this world of Zoom, whose child had a hearing test in August of 2019. After those services were rendered, they knew they would owe the doctor because the explanation of benefits came from the insurance company. That amount was $355.37. After 7 months, like Senator Claxton's experience, they still had not received a bill from the provider. The constituent asked what laws were in place regarding late billing, and I learned there were no statutes addressing this issue. Since putting this legislation in, I've heard from a number of folks who have similar stories One who, after 18 months, was told they owed almost $100,000 for a childbirth. The point of this legislation is not to make it more difficult for healthcare providers to do business in Maine, but to try to make it so individuals receive their medical bills in a reasonable amount of time. I would like to offer an amendment today, which your clerk should have distributed to you. If not, we'll make sure you get it. I'm asking for the committee to consider making this legislation apply to healthcare facilities that employ over 40 people to help ensure that it's impacting some of the larger providers who have full-time billing departments. In recent weeks, I've learned a lot about how medical billing is done and the requirements that providers and insurance companies have to follow, and I'm sure I've not even scratched the surface. This legislation is not a panacea in solving the issue at hand, but I believe with everyone working together, we can come up with a solution that is better than people receiving bills well after they receive their medical care. Thank you for your time, and I'd be happy to answer any questions you may have.
Thank you, Senator Pouliot. Are there questions for Senator Pouliot? Okay. Great.
Thank you all.
So, seeing none, thank you, Senator Pouliot, for presenting the bill. And we are going to, like I said, combine the hearing on these two bills. So next, I would take any testimony in support of the bill. If there is anyone who wishes to testify in support and that you're in our Zoom room as an attendee, please do raise your hand at this time. You should have that raise hand function. Great, excellent. I was hoping that would happen. So we do have someone who wishes to testify in support, and we'll be pulling him or her into the meeting now. Great, excellent. Ms. Knapp, you may start your video and unmute yourself and join us. Great, please go ahead.
I think I'm unmuted.
You are, we can hear you, go ahead.
Okay. Great. Good morning, Senator Sanborn, Representative Tepler, and members of the committee. I am Stacey Knapp. I am that constituent who reached out to Senator Pouliot. I am a mother of two. I have a daughter who's 3. Today is actually her birthday. She's very excited. And I have a 5-year-old son. If any of you are parents, you know firsthand that having kids means there are a lot of medical bills, even if everyone's healthy. There are childbirth bills, NICU bills in our case, which we're still paying for 5 years later, bills from early morning sick visits to the pediatrician, lab and testing bills, dental bills, and unexpected bills from visits to urgent care and the emergency room. Now, that's just how it is. And I'm extremely grateful that we have easy access to these services and have healthcare coverage through our employer to cover some of these expenses. Both my husband and I are working parents. We both are state workers. We are a 2-household income, and for our area, our income is certainly a livable wage. That said, there is no extra. We plan and budget and we're able to pay our bills, but unexpected bills are very much a hardship. They throw our budget for a total loop, and even if we're on payment plans, that kind of stretches out that mess up in our budget. But we plan as best as we can to reduce this hardship. Like many families, we both have flexible spending accounts through our employer to cover medical expenses. And we budget enough in those accounts to cover any expected medical bills, such as the birth of a child when we knew that was happening, any known dental work, glasses, copays, and even a couple of those $300 bills that we know it costs the second we walk through the emergency room door with our insurance. We depend on our flexible spending accounts to cover our out-of-pocket medical expenses. It comes out of our paycheck, but it's kind of saved for us in a pre-taxed account, which is great. It's a huge savings being able to use that pre-tax income for medical expenses. And for the most part, that works out really well for us. When it doesn't work out is when the hospital doesn't bill us in a timely manner. You see, flexible spending accounts can only be used for services received during that calendar year. In the case of a late year visit, we have a 3-month grace period, or until March, to pay that bill using the money in our flexible spending account. After that 3-month grace period, it's no longer legal to use the money we've set aside for that year's medical expenses, even if those visits happen during that year. We no longer can take advantage of the savings or that money that we've set aside. I've received numerous bills at 9 months and 12 months after service from the hospital, both for the birth of both of my children, from the NICU, and for routine office visits. I can't say I've ever received bills that late from specialists or for outside lab fees. Hospital bills, though, are the big ones, right? They are hundreds to thousands of dollars, and sometimes you don't know what they are. You have no idea how much a Tylenol costs until you get that bill. As you can imagine, these are a huge hit to our budget, and an unnecessary hit, in my opinion, because if we received those bills in a timely manner, we could plan and we could budget better. And we can use our flexible spending account and get that savings on the cost of those bills by using those pre-tax funds we set aside for those expenses. The hospital routinely points the finger at the insurance company, and I don't claim to understand how that process works, but I do know that I typically receive a statement from my insurance provider relatively quickly telling me what I should expect my out-of-pocket expense to be, and I can use that to plan, which is very helpful. I'd like to specifically cite the most recent delayed bill we received, as Senator Pouliot mentioned. 4 months ago, in late October of 2020, I received a bill for that $355.37 from Maine General for a hearing test that my daughter was given in August of 2019. That's 14 months after the visit. I received our very first bill. I had received a statement from my insurance provider only weeks after the visit listing the patient owed amount of $355.37. So we earmarked that money in our FSA account to pay that bill. But as we approached the end of December, we had to make a decision. As you know, if you don't spend the funds in a flexible spending account, you lose them. So by the end of December, you need to either spend that money or be positive you're going to be able to pay that bill by March. Frankly, since I never received a bill from the hospital, I began to think that maybe they weren't going to charge us. I know that sounds weird, but my daughter was only 18 months old and we had no concerns about her hearing. It was a just-in-case screening our pediatrician recommended because she hadn't started talking yet. Now she won't stop talking. When we arrived, the audiologist quickly admitted she can't really test the hearing of an 18-month-old other than to make a sound and see if she looks, which we could already confirm. So we thought maybe they just kind of made it go away because they couldn't really do anything anyway. That wasn't the case, but regardless, if we had received the bill by March, 7 months after the appointment, we would have been able to use our FSA account, saving us both the tax and the state and federal income tax on that $355. I'm not sure exactly how much income tax is. My accountant does our taxes, but it's at least 20%, right? So that would be $70 on that bill. That's 3 boxes of diapers that we didn't get, that we didn't have paid for, simply because the hospital billed us late. Late billing isn't just an inconvenience. It doesn't just throw your budget for a loop. It actually costs patients more money through the loss of income tax savings, only possible within the time restrictions of an FSA account. And I know that a lot of families like us use those, and it's the only way that we can really pay those medical bills throughout the year. For that reason, I believe billing should be required within 3 months, but I understand that there are a lot of hoops that hospitals have to jump through, and 6 months is a huge step in the right direction. I thank you for listening, and I hope you will seriously consider the impact late billing has on Maine families and push to require billing within 6 months. Thank you.
Thank you, Ms. Knapp. That was very helpful testimony. Are there questions for Ms. Knapp? Representative Tepler.
Thank you very much, Madam Chair, and thank you so much for that enormously helpful testimony, Ms. Knapp. I appreciate your being here, and I appreciate your analysis of the situation with the FSAs. I too have an FSA, so I understand exactly what the concern is. I guess what I want to understand more clearly for the work session, and this may not come just from you, but perhaps from others, is whether these bottlenecks that you experience so that you get billed very, very late are coming from hospitals, are coming from provider groups, or from other sources. I guess it's pretty important to understand, for the committee to understand clearly where the source of the bottleneck is. And I hear you saying that the hospital is pointing the finger at the insurance companies, but your insurer is in fact informing you of what's due. So yep. I guess in your case in particular, we're looking primarily at hospital bills. That's the problem?
Yeah, I've always received bills from specialists within a few months. That's been my experience. And it's always the big hospitals. It's the Portland, the Bangor, and the Augusta Hospital that I've received those late bills from. Frankly, those are the whoppers. Those are always the biggies. Mm-hmm.
Okay. Thank you, Ms. Knapp. Yeah, I guess I'd like to ask Colleen if there's any data available. It would be helpful to have some data.
Great. And I wanted to ask you, Ms. Knapp, for our records, what town you reside in.
I'm in Augusta.
Great, thank you. All right, are there any other questions for Ms. Knapp? All right, seeing none, I would take any additional thank you very much, Ms. Knapp, for being here, and I will take any additional testimony in support of the bill. If there's anyone in the committee room who would like to give supportive testimony, please raise your hand at this time. All right, seeing none, I'm going to turn to opposition testimony and invite Jeff Austin to join us. And just to clarify, I can, Mr. Austin, hang on just a second. Just to clarify, if you've already signed up to testify, you don't need to raise your hand, but I will use the raise hand feature as a backstop, let's say, in case somebody might have either registered in the wrong category, which is what happened this morning, or whether someone might have forgotten to register. So between each section, support, oppose, neither for nor against, I will invite folks to raise their hands. So if you're in the attendee room and have already registered, you do not need to raise your hand to testify. I will go through my list of registrations. There we go. All right, so Mr. Austin, with that, please go ahead.
Senator Sanborn, Representative Tepler, members of the committee, my name is Jeff Austin. I'm here on behalf of the Hospital Association to testify in opposition to both bills. I do believe the two bills are different, even though the wording is identical, and I think Representative Morris teased out the distinction. That distinction was teased out last year as well. So I would like to address the distinction between the two bills, even though the wording is the same, if given the opportunity. Let me first state that what you heard from Ms. Knapp does happen. Bills do arrive more than 6 months after service occurs. It's unfortunate. It is an inconvenience to the patient, and I think the hospital community recognizes that. The challenge with this kind of legislation, which has been proposed in the past, you've touched upon. The hospitals don't 100% control this process. Providers submit claims to carriers. Those claims get adjudicated. That process can take time. We cannot send a bill to a patient until we know what the patient owes. We don't know what a patient owes until the carrier tells us. I think the Ambulance Association has submitted testimony that said, if you want to make it 6 months after the carriers tell us what the amount is, they would live with it. I think we said that last year as well. But we cannot send a bill to a patient to pay until we know what they owe. The woman who testified said that she got a notice very quickly from her carrier as to what she was going to be responsible for. I don't get those notices. I don't think that's very common. You can frequently get an explanation of benefits that sort of tells you what's been billed, but not the adjudicated amount. That's our challenge. I think you have testimony from Northern Light Health System that 90% of their claims are out the door to the carrier, back from the carrier adjudication, and out to the patient within 6 months. But they're about 10% of the time, it takes a little bit longer than 6 months. And that is a pain. But what the bill does is ask the provider community to bear 100% of the responsibility for a process we don't 100% control. When I presented this bill to my members, I mean, they exploded on the issue of how difficult it is to process claims. I'm not going to go down that road. It doesn't matter to the patient. Is it our fault? Is it the carrier's fault? The back and forth finger pointing between the two of us about how long it can take to wrestle a claim to the ground. It doesn't matter to the patient. It takes time. The challenge with this legislation and where we think it's unfair is we can't forego 10% of our claims, and even more than that, because as it typically is a bigger, more complex claim that takes time, for a process that we're not in charge of. I mean, we could move to a system, it might require law change, like my dentist uses. They take a credit card the day of service. We pay out of pocket up front, day of service, like most other businesses. and then they bill the carrier, and we wait for the carrier to send us a reimbursement check. If you want the bill timely from a provider, we can move to that system. Pay up front with a credit card, like I do my dentist. And then the waiting is all with the carrier adjudication process. You wait for your reimbursement. I don't think we can move to that system. Most people can't pay some of these bills immediately and wait for a reimbursement from their carrier. So we would ask you, as in years past, not to do this legislation because we don't control this system. It is very arduous. It's different from carrier to carrier. By and large, we're complying with the 6-month deadline. But when we don't, it is a two-person, and sometimes it is the patient as well. Sometimes there are patient information needs that don't come in in a timely way, particularly like if there's third-party coverage, homeowners insurance, or automobile accident situation. So if you want to make it 6 months after we're told what the patient owes, we can bill them. But how are we supposed to bill them until we know what they owe? 2 other quick points. I appreciate you giving me a little extra time. One is, and you'll see at the end of my testimony, you're amending Title 22, which governs everything hospitals do as opposed to the insurance statutes. And you would be changing how we bill in Medicare and Medicaid, which I don't think you should be doing. So I think this should go back to Title 24. And then lastly, let me just close by saying, we don't need, as the provider community, motivation to get the bills out the door. We've provided the service. We've incurred the cost. We have every interest in getting paid as quickly as possible. Waiting 6 months is not beneficial to us either. Every business wants to get paid immediately. We will move as fast as we can. There's a whole section of hospital management, revenue cycle management, devoted to trying to get paid as quickly as possible. We don't need that motivation to get the bill out the door. But we do have objections to a legislation that asks us to bear all of the responsibility for a system we largely don't design and control. I do believe Senator Claxton's bill is slightly different. My written testimony addresses what Rep. Morris teased out, which is he's kind of more of I want a heads up notice to go out to the patient that they will at some point be getting a bill, but that it's in the process of adjudication and just heads up planning purposes. So I can stand on my written testimony for that. With that, I appreciate you giving me a little extra time, and I'd be happy to take any questions.
Thank you, Mr. Austin. Representative Malrano.
Thanks, Mr. Austin. And thanks, Madam Chair. So I wanted to ask, what are the hospitals doing to address their billing issues, which to my understanding are numerous? And you've even said that before. And just in my family alone, I can think of 2 or 3 instances where there have been billing issues to the detriment of the patient, of course. What are, if this is not one of the solutions, what are the hospitals working on to address their billing issues?
Well, one, I don't always agree that the delay in the bill is due to the hospital. There's a lot of back office fighting over claims. And I got an earful about the stuff that goes on. We submit a bill for a claim. The carrier unilaterally adjusts the coding in the claim and pays a different amount. That sets off a fight. I get a lot of stuff that comes across my desk. I just got an email of a national survey of health insurance plans on the individual market and the denial rates for claims in the individual market. Maine's Anthem plan had the 2nd highest denial rate for claims in the country, according to this email. 40%. 4 out of 10 claims denied. That's not 40% fraud. That's billing thicket that it is very difficult for all providers to get through accurately. The billing thicket at each carrier is different. The requirements are different, and it's a pain. But 40% of claims are denied. Once you're denied, you're into the denial fighting that we do while the patient sits and waits. It's not that we're perfect. We're not. I'm not pointing all fingers at carriers. We make mistakes. We'll send 2 bills. We'll bill the wrong thing. But we have seen this legislation a lot. We do have a bill in this session. It has not yet been printed. It seeks to get at this issue a slightly different way. I'd be happy to, and I look forward to discussing it with you when it is printed.
Representative Melrani, do you have a follow-up?
I mean, I guess my follow-up would be on those instances where it is the hospital's fault. And it is sometimes, you know, is there a concerted effort right now to look at billing systems within hospitals?
There is a multi-$100 million industry devoted to revenue cycle management. How do you get the bill out and paid as accurately and as quickly as possible? It's not that we don't screw it up, but we have no incentive to screw it up. We provide the service first and we get paid later. It's an unusual industry in how long we wait to get paid. We could do it easier, like the dentists do, and bill your credit card day of service, submit your claim to the carrier, and then wait for the carrier to write you your reimbursement check. You can't afford it. The public can't afford that system for many bills. So yes, when we screw up, we lose money. So not screwing up is a huge concern for hospitals because we wind up typically losing money over it, not making money over it. I mean, I can get you billing people in. You've had them come before this committee before. I mean, hospital staff on billing is massive these days. We can bring them forward to you and you can interrogate them over what they do all day. But
Okay.
it'll blow your eyeballs back. They are frustrated
Okay.
people.
We've got a lot of hands up. I want to move through those members of the committee as quickly and efficiently as we can. So I think next we had Representative Matheson, followed by Representative Morris. Go ahead, Representative Matheson.
Thank you very much. And thank you, Mr. Austin. I own a private practice and I'm in charge of all of the insurance billing, so I feel your pain. My question is really directed towards this particular case. Our experience as practitioners is when the patient does receive EOB, we usually get notification within 2 to 3 weeks after that. They may get the EOB before, but we are very clear about whether or not, one, the service is denied, or if there's a discount associated to it, or if there's some deductible that has been applied to it. So we know what the patient is responsible for within 2 weeks of them receiving the EOB. I just don't understand from a hospital basis why you wouldn't have received that information with that last situation, when it was very clear that she owed $355 from this one visit. She received the EOB, but she didn't get something till 14 months later. That seems like a billing issue at the hospital side, because that's not what happens with my private practice. So I just want to get clear definition on how and why that would happen.
Right. Let me give you 2 answers. Neither of them will be direct. The first answer is that's why I think you can do something like post-adjudication 6-month deadline. If it's fully adjudicated, can the providers get the bill out in the 6-month deadline? The second, and I'm going to give this answer to the committee a lot, unfortunately, as I testify before you, I'm prohibited by law from picking up the phone and asking Maine General what happened in this particular individual's case. I can't, it's against the law for me to find out individual circumstances. I wish I could. We can't I can't call up and say, hey, Miss Knapp said she didn't get a bill. What happened? They're not allowed to share that. It comes up a lot on clinical issues. Hey, a doctor treated me a certain way. So it's a part of your life. You are going to get half of the story in detail frequently. What the other half of the story, I'm not allowed to find out. But
Representative,
cutting to the chase, post-adjudication legislation is different than pre-adjudication deadlines.
Okay, I think I understand your answer. So you're indicating to me that in this situation, likely that they didn't receive information back from the insurance company till 14 months later for adjudication, which doesn't make any sense to me based on my experience, but I appreciate your information. Thank you.
Yeah. To be clear, I'm not saying one way or another what happened. The hospital may have been completely on the hospital's end. That does happen, in hundreds of thousands of bills. I'm not arguing that. I don't know what happened.
Representative Morris, followed by Representative Bleier. Go ahead, Representative Morris.
Thank you, Madam Chair. My question is, you referenced the issue with the, as you said, with what happens with dentists, because I think the concern here deals with the issue of this being an FSA and a use it or lose it situation. So I didn't know, I guess the question is, how would it be possible in some of these situations to sort of ballpark what you think it's going to be, or is that not possible because you have to look at every individual case differently, where they could pay that money, as you said, and then have it credited later if they overpaid in that situation? I don't even know if that would work with FSAs, but I didn't know if that was something that you could do on your end.
Yeah, two things. A big portion of what a patient is going to owe is not the price of the procedure, it's where they are in their deductible.
Okay.
And that we don't always know. Earlier in the year, we can guess that they're early in their deductible and might owe the full amount of their deductible. And the other thing, if it's co-insurance, 10% of the claim, then it is tied to the price of the claim. But it may be 10% of the claim up to the amount of their deductible. So carriers are in a better position to tell the insureds where they are in their deductible. I was being somewhat facetious with the credit card issue because, again, 90% of the time these bills are in and out within 6 months. I was surprised that it was a hearing check, small $300 bill at the root of this. We're typically in the thicket with the carriers on the big expensive claims. And in their defense, I don't know if they're testifying today or not, they're trying to do everything they can to keep healthcare costs down and scrutinize every bill and make sure there's not improper utilization. So I think the world wants them to scrutinize bills, but it can take time.
Okay.
Representative Morris, did you have a follow-up?
No.
Okay. Representative Bleier, go ahead.
Thank you, Madam Chair. Thank you, Mr. Austin. I believe that 6 months is sufficient amount of time for a patient to get a bill. Now, if I heard you correctly, the hospitals are spending around $100 million to try to correct billing. And I'm sure that hospitals are trying to retrieve their resources, from billing services as soon as possible. My question, though, is putting legislation, if the problem is existing and it's still existing and it's a continual problem, and we're spending $100 million and we still haven't fixed the problem, legislation like this put in place, wouldn't it force your hand now to fix the problem?
Well, thank you for the question. I think the challenge is for us, if the legislation passes and the claim has not been fully adjudicated within 30 days of 6 months. So if 150 days have gone by and we have not got final adjudication, what do? Send a bill for the full unadjudicated amount to the patient? That's gonna have a lot of your constituents angry, stressed, confused. I put somewhere in one of my 2 testimonies that I think years ago, as part of Dear Ago, they did have providers send out shortly after service sort of a detailed, itemized account of the service they received and the prices. And I wasn't the lobbyist for the Hospital Association at the time, but my understanding is that that stressed a lot of people out. Why are you sending me a bill? Send this to my carrier, da, 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 da. And right on top it said, this is not a bill. We're just telling you what's been submitted on your behalf as a claim. You're going to owe potentially some portion of this depending on your policy. So we will comply with the law. I don't know that it will lead to less stress for your constituents. I'm sorry, we will comply with it, but if that means at 100-day 150 sending out the bill for the full amount, we'll send it out. And we will screw up. And if that's what happened in Ms. Knapp's case, we will have missed our deadline and she will have gotten the service for free.
Representative Blyer, did you have a follow-up? Okay. Representative Evans, go ahead. Is Representative Evans, can you hear us, Representative Evans? Go ahead.
Thank you. I can hear you. Can you hear me now?
Yeah, you may want to turn off your video as you're a little bit low on bandwidth. Great. Go ahead.
Okay, can you hear me now?
Much better. Thank you. Yes, go ahead.
Okay. Thank you, Madam Chair. Thank you, Mr. Just as I am in individual private practice, and billing claims is a significant priority for me. The problem that I see is, and which leads me to the problem that I see is timely claims processing. And it raises the question for me, are your facilities, hospitals, during internal claiming, or are you using an external agency for the claiming? Because this is a significant problem.
I believe on both sides, both the carriers and providers, some do use third parties. I don't have the answer at my fingertips as to what every hospital in Maine does. I think most do internal billing, but I don't know that for sure. And I know on the carrier side, they have third parties audit claims and review claims as well. There are third parties involved on occasion. But I don't know statewide. I apologize. I don't have that.
Okay. Are there additional? Thank you, Representative Evans. Are there additional questions from the committee for Mr. Austin? All right. Seeing none with that, we thank you for your testimony, Mr. Austin, and we'll move on to Gwen Simons. Not Simmons. Ms. Simons.
There we go. Can you hear me now?
We can.
Great. Thought I clicked the wrong button and left the meeting for a minute. Good morning, Senator Sanborn, Representative Tepper, and honorable members of the committee. My name is Gwen Simons. I am the lobbyist for the Maine chapter of the American Physical Therapy Association. I am a physical therapist myself, and I practice health law in Scarborough. The Maine EPTA represents about 2,500 physical therapists and physical therapist assistants in the state. And it's primarily our private practitioners we're concerned about, because the hospitals, bill under the hospital. But we are opposed to LD 167 and 367 as written. I had submitted previous testimony which pretty much agrees with everything that Jeff just said, as those being the carrier issues. But I want to draw your attention to a couple of issues that will need to be resolved, and maybe the bill be amended for this bill to not have unintended consequences that severely harm our private practices. We do agree with the intent of the bill, so thank you, Senator Claxton, for bringing that issue up. But that's not what the bill says, and we question how it's going to be interpreted. And I want to give you a couple of, well, at least one specific example. I've represented in my law practice 3 providers who have been put on prepayment review by Anthem, and all 3 of those providers were physical therapists, chiropractors, and acupuncturists, and put on prepayment review for questionable valid reasons. In those situations, Anthem required the provider to submit paper claims. They were lost once they were submitted. They had to be submitted multiple times. Some of the bills for one of my clients still have not been adjudicated after about 1.5 years or longer. The provider in one of my providers tried to bill the patient, or not bill the patient, but at least send them a statement. And they were promptly told by Anthem they could not do that. We contacted the Bureau of Insurance to complain about the claims not being adjudicated in a timely manner, and that we felt like there were unfair claims handling practices going on. And we were told by the Bureau they don't get involved in provider and payer disputes, and that the patient should not be billed until the dispute was resolved. Now that provider has not been able to even bill the patient for the patient's estimated share, either the deductibles or the co-payments, not co-payments, but the co-insurance, sorry. Co-payments are collected at the time of service because we know what that amount is going to be. So if we move forward on this bill, we need clarification on whether sending a billing statement violates Maine's hold harmless law, and we need clarification or some approval that we can, explicit approval that we can bill the patient for their estimated portion of the bill before the carrier adjudicates the claim. Otherwise, we are punishing the provider for the carrier's conduct, and that's just not fair. The other concern is that providers are going to have to prove that they sent a bill to a patient. How are they going to do that? We are concerned about adding administrative cost if they have to send out statements, certified mail to prove that they sent something within that time frame. So if we can resolve some of those issues, I think we would be in more support. One of the things I want to address about what Jeff brought up, though, is adding the 6 months from the time the claim is adjudicated. First of all, if it's adjudicated, we don't even need 6 months to send the bill out. But in these situations where the claims are not adjudicated for more than 1 year or maybe 2, then the patient is still going to be upset. We are also concerned about our ability to be able to estimate what the patient's share is going to be. But if we can at least try to do that so that the provider is not left with carrying the debt load of that unpaid bill forward, then I think we could potentially agree to the bill. It just needs some substantial amendments. So we will be around for your work session, and we appreciate the opportunity to give comments. Hopefully we will have some of our private practitioners contact you individually to tell you their stories.
Thank you, Ms. Simmons. Are there questions? I keep calling you Simmons. Thank you, Ms. Simons. I don't know why I'm doing that. Are there questions for Ms. Simons? All right, seeing none, thank you for being here today. And next I'm going to call on Sarah Calder. Good morning, Ms. Calder, go ahead.
Thanks, Senator Sanborn, Representative Tepler, members of the committee. I don't have too much more to add from what Mr. Austin testified. I would also echo, he mentioned Northern Light. So 90% of our claims, our statements are sent to patients within 90 to 120 days. I don't want to take too much of your time. So I just did want to provide a few examples where the timeline could be extended further, and would just add that we understand that this is a problem and would agree with Jeff that, sorry, I should have mentioned that earlier. We agree with Jeff that this legislation before you today doesn't get to the root of that problem. So there are just a few examples where the timeline can be extended further. If a claim needs to be overturned after being denied in all levels, we've seen issues, some outlier issues where this has taken years to resolve. Post-payment reviews and audits, coverage by multiple insurers, which Senator Claxton addressed, and then the high dollar payment reviews, which happens, as you can imagine, more frequently at Maine Medical Center. So happy to be part of the work session, and again, don't want to take up too much of your time, but thank you so much.
Thank you, Ms. Calder. Are there questions for Ms. Calder? All right, seeing none, we thank you for your testimony. And next, I'm going to call on Ann Robinson. Good morning, Ms. Robinson. Please go ahead.
Good morning, Senator Sanborn, Representative Tepler, members of the committee. My name is Ann Robinson with Pierce Atwood, and I'm here today in opposition on behalf of Spectrum Healthcare Partners, which is a multi-specialty physician practice group that provides services throughout Maine, or one or more of its array of services throughout various parts of the state of Maine. As Ms. Calder said, I don't have a whole lot more to add. I guess I do want to just emphasize, though, the point that Mr. Austin alluded to, that this bill as written captures Medicare. And I mean, that's a problem because there are legal requirements under Medicare that this legislation would be in conflict with. And secondly, you know, I think that his suggestion that if there is going to be some sort of time frame imposed by this legislation, that it really be tied to the provider's receipt of the adjudication of the claim. And I would just emphasize in that regard that, you know, it needs to be the final adjudication by the carrier. And finally, I'll just say that I think, you know, I share, you know, Mr. Austin's comments that it's certainly in the provider's interest to send out bills in a timely manner. So we're as frustrated, you know, by the process, I think, as anyone. So with that, I'll stop. I'm happy to answer questions and be available at the work session. Thank you very much for your time.
Thank you, Ms. Robinson. Are there questions for Ms. Robinson, Representative Tepler?
Thank you, Madam Chair, and thank you for being here, Ms. Robinson. Ms. Robinson, oh shoot, I think I just forgot my question. I'm sorry.
I'll be at the work session if you want to ask.
I'm going to have to come back to it. It was in reference to something specific you said, so thank you. I'll have to review your testimony and think of my question again. I apologize.
Oh, thank you.
It happens. All right. Anyone else have questions for Ms. Robinson? All right. Seeing none, thank you for being here this morning. That concludes my list of folks who were pre-signed up for opposing the bill. Before I shift to those who wish to testify neither, oh, you're right. I'm glad I said that. So next I'm going to hear, I forgot to look at the other list of opposition to the bill. So I do have a couple more people on the list to oppose the bill. So next I will turn to Holly Lusk. See, this raise hand function works great.
Yes, it does.
Perfect. Welcome, Ms. Lusk. Go ahead.
Hi, everyone. Thank you. Thank you, Madam Chair. Thank you, Madam Chair. Members of the committee, my name is Holly Lusk, and I represent Fresenius Medical Care, which operates close to 20 dialysis clinics across the state of Maine, from Eastport to Wilton to York County. I am speaking in opposition to the bill or both bills for several of the reasons that have been mentioned already. I do want to follow up with what Ms. Robinson said. Most of our patients are Medicare patients because dialysis is primarily something that is treated through Medicare. So I just want to reiterate what she said, that that would be a problem for many of our patients. With respect to those of our patients who are covered by private health insurance, the only situation that we have found in Maine where we rarely would go beyond the 6-month period of time has been for those patients who have provided incorrect insurance information. Either they changed jobs or their job changed plans and they were not aware of that. And so the incorrect company or carrier was billed for that. And so sometimes that has resulted in claims going beyond 6 months, but it has been a rarity. So that's all I wanted to tell you today. I actually will not be available for your work session. So if you have any questions really related to the provision of the dialysis services, please feel free to contact me via email through your clerk. Thank you.
Thanks so much, Ms. Lusk. Are there any questions for Ms. Lusk? All right. Representative Tepler, go ahead.
Thank you, Madam Chair. Thank you for being here, Ms. Lusk. I want to better understand what happens to a patient in terms of billing when their employer changes insurers.
Well,
if
sorry.
A employer changes insurers between the time that a patient receives the service and receives the bill, what happens to that patient's billing situation?
Thank you for the question, Representative. So for us, it might be a little bit different than most providers because we see our patients 3 times a week. And so most of those conversations that we have about billing would actually be done in person because, you know, again, a patient is coming in for dialysis 3 times a week. We see them frequently. So we would not tend to communicate that via a letter. It would tend to be something that is done in person or via a phone call. And so in the situation where, let's say someone changes jobs or their employer changes plans, for example, the original plan would be billed. The carrier would let Fresenius or presumably any provider know that that plan no longer covered that particular individual, or that carrier was no longer, that individual is no longer enrolled with that particular plan. And then what would happen is Fresenius would get in touch with the patient, again, usually in person, and would then say, hey, the insurance came back and it says that you're not covered. Do you have different insurance? You know, did you change jobs? You know, do you have a different plan? That sort of thing. And then we would bill the correct plan. It actually is something that happened to me recently where I had I went to go see a practitioner and they had an old insurance for me. Neither of us knew that they had the old insurance. They billed the old insurance. And my old carrier actually sent me an explanation of benefits, even though I was no longer on that plan, to indicate that I am no longer covered under that plan. And that, you know, here's your patient responsibility. I took a look at it and said, oh, they have the wrong insurance. I called up the practitioner, provided them with the updated insurance information. And then that practitioner then went and billed the new carrier. So
if I can follow up, Madam Chair. Thank you.
Go ahead.
So what I'm understanding from what you're saying, Ms. Lusk, and I guess we may need to confirm this with other providers, particularly the hospitals, is that if the bill for a service goes out after your employer has changed their insurance carrier, then the insurance carrier who was responsible at the time of the service provision is no longer responsible for that charge. Is that correct?
Well, what I'm saying is it simply goes on, like, let's say a calendar year basis. So if, let's say I'm the patient we're talking about, let's say I have Harvard Pilgrim through the end of 2020, but then I have Aetna starting in 2021. and my practitioner doesn't know it. So let's say I got, I went in for a service on December 28th. Or let me back up. Let's say we start services in January of this year, but I haven't provided the correct insurance to the practitioner. They billed the old insurance. They billed Harvard Pilgrim. Harvard Pilgrim would then tell me as a patient, even though I'm no longer covered by them, at least this has been my experience, they would send me an explanation of benefits saying, you're no longer covered under the plan. You shouldn't expect to receive any coverage from us for this. And at that point, it was my responsibility to then communicate to the practitioner that they had the wrong insurance information. So then I provided it to them, and then they billed the correct insurance company. So, I mean, the insurance companies are responsible for what is what is done during their plan year. But if it's something that is, if it's a service that's performed in the new plan year, well, then it's a separate issue. I think we're talking about when the service is performed, not necessarily when the bill gets sent.
That's right.
But that's my understanding, and certainly they can speak for themselves. So.
Yeah, but that's right. Representative Tepler, does that answer your question?
Yes, that is the explanation I was looking for. Thank you.
Okay, great. Thank you, Ms. Lusk. Are there any other questions for Ms. Lusk? Okay, seeing none. It looks like Dan, thank you, Ms. Lusk, for being here. And it looks like Dan Moran would like to testify in opposition, so we'll bring him into the meeting now. Hello, Mr. Moran, go ahead.
Hi, good morning. Senator Sanborn, Representative Tepler, members of the Joint Standing Health Coverage Insurance and Financial Services Committee. I'm Dan Moran, Director of Communications and Government Affairs for the Maine Medical Association. We represent more than 4,300 physicians, residents, and medical students, ranging from hospital employed, health system employed, large independent practices, all the way down to the solo practices in areas like Steep Falls and Millbridge in Washington County. I won't repeat things that have been said before, but we oppose both bills for several reasons based on feedback from numerous independent physician practices over the past few weeks. A couple comments in my testimony. Some commercial payers encourage practices not to bill the patient until the plan is processed and adjudicated the claim. And there are a list of bullet points in my testimony of circumstances where claims frequently take more than 6 months to adjudicate. That's a compilation of responses I received from many independent practices. They range from workers' comp to CHAMPA to Medicare, exchange-based high deductible plans, managed care plans. If these pass and the law required us to bill within 6 months in all instances, we'd be forced to either bill patients directly before the health plan is adjudicated, as Jeff has indicated earlier, or we'd be forced to eat the cost of service. One of the questions that brought up, what constitutes billing a patient and what's the confirmation for billing a patient? If it's an electronic bill and the patient claims to not have received it, who arbitrates that? If, it drives me crazy when I go into my physician's office. It seems like every single time I have to refill all my information, my address, my phone number. And I say, didn't I just do this last week? And it has been actually a year. So if you don't update the contact information as a patient, or the patient doesn't provide the updated information, the bill might go to the wrong plan or the wrong address. Is the practice on the hook for failing to timely bill in that case? And how do we prove in instances and anecdotes where the patient claims not to receive a bill that they did receive a bill or they didn't receive a bill? Do we have to now do certified mail? Do we have to have them pick it up at the post office? An example from an oncology practice member for a pathology claim is in my testimony. They billed it in March. It was denied. They appealed. They appealed a second time when it was denied. They had to exchange medical records. The practice was finally paid in December, 9 months after the revenue cycle due to administrative requests. These bills have passed would negatively impact medical practices and their patients. They were uniform in saying that. Your patients may get started, your constituents may start getting informational bills, as Jeff said, at the same time in order to comply with the law. That would lead to confusion, increased calls, administrative costs. And I have detailed examples on the last page of my testimony that go into the weeds as worker comp, Medicare participation, and actually talks about auto and homeowners insurance, which wasn't discussed earlier. In many cases, subrogated payments, whether it's an injury from a homeowner's policy or an auto insurance policy, may further delay the claim because then you're dealing with two different types of insurance carriers. And a couple comments made earlier. One of the bill sponsors indicated there was an amendment for more than 40 employee businesses because they have quote unquote bigger administrative offices. A lot of the feedback I got were from the larger independent physician practices and the problems that they would face with this bill, as well as the smaller independent practices. I would echo what Jeff said. Oftentimes with anecdotes on healthcare, you're hearing about one side of the issue. It's not an indication that you shouldn't believe the anecdotes from your constituents, but because of HIPAA and healthcare laws that differ from other businesses where payments are required and remitted immediately, we can't look back and find out the process and present that to you in order to counter some of the anecdotal claims that you hear on this bill or any other bill. And I would make a comparison again to roof. The final statement would be, homeowners insurance or vehicle insurance, not necessarily from a billing perspective, but every time I've gotten my roof replaced at the homes I've owned, I know what I'm going to pay up front. It's already dealt with by the insurance company before they even lay a tile on my roof. And it's the same for getting my car fixed at the car insurance. Health insurance is just different. Doesn't mean it's right, doesn't mean it's wrong. It's frustrating. I don't even understand it. But those are the comments I received from our members, and we'd be happy to take questions back to those members that you may have and appear at the work session virtually to answer any other questions. Thank you.
Are there questions for Mr. Moran? All right, seeing none, we thank you for being here today, Mr. Moran. Thank you for your testimony. So next I will turn to those who wish to testify neither for nor against the bill. And I will start with Robert Reed. Welcome, Mr. Reed. Please go ahead.
Thank you for allowing my testimony today. Bear with me, it wants to mute me. To the chairs and the members of the committee and to the legislative staff, my gratitude for allowing my testimony in the bills before you. My name is Robert Reed. I'm the Executive Director of the Maine Chiropractic Association. My testimony today is neither in favor nor opposed to the bill, but to give a personal perspective from my experience of where the bill could be modified for a better outcome. In my career, I've spent 13 years working for two major health insurers in Maine, and over the past 20 years, working for healthcare providers, both large and small. My perspective is formed from both viewpoints, with an understanding that there are some unintended consequences that could appear with the bill as proposed. No one wishes to get a bill 6 months later or longer, but it does happen more often than you realize. A few examples. Patients are required to provide health insurance information, but at times the information could be incorrect or out of date. If the wrong information is provided, those delays can actually cause claims to be denied for timely filing. In many cases, if you can prove you have new insurance and you were notified later, the carrier may what they call restart the clock and allow you to accept the claim and pay for it. But again, it's an appeal process. It's gone from denial, as was mentioned by the hospital folks, and it's a little bit more difficult. Second example occurs in worker compensation. If the employer controverts the claim, you may spend months or a year back and forth before they decide it's not a work comp. If you bill the patient, they may say, well, bill my health insurance. Again, we're back to timely filing, getting through that, and then charging them any co-insurance and deductible, which our contracts for our doctors say you can't bill those amounts until you have the final decision from the carrier that notifies you. The greatest concern, however, is the claims that result from auto accidents and other liabilities, as Dan mentioned. These can take years to finalize. You, as a good billing company, the best practice is to call the attorney's office once a month and ask for an update. Any more than that, you become a nuisance to them. So we recommend calling once a month, getting an update, finding where the case is. At some point, under Maine law, we're now told the patient's been paid for this. So the patient got all the money, including what was paid to the doctors, and we're expected to bill the patient. If this case has gone for multiple years, we wouldn't be able to do that under this bill. So again, the bill offers the best of intentions, but its effects could really help hinder the health community. A couple of thoughts on how this could be a better bill. As indicated, combining it with 367 absolutely makes sense. They are the same bill for most part. I do appreciate Senator Pouliot's mention of exempting those smaller offices with less than 40 employees. These smaller staff typically have just one person to do the billing and to chase everything. Third, consider a restart the clock option, where that timeliness for the patient begins after the providers know they have final and they're okay to bill the patient. Fourth, consider making an exemption of those claims which arise from work comp, auto, or other liabilities, or those involving litigation. Consider moving the filing deadline to a year instead of 6 months. That would be the lesser option to take, but it is an option. Lastly, consider including a provision that allows a healthcare provider to notify the patient of an outstanding bill unresolved with third parties such as attorneys, insurers, or others, and allow that to become the restart for the allowed deadline for late billing. Any and all of these suggestions will make for a better bill that will still ensure no late surprise billing, which is what we all want to avoid. I thank you for allowing me to testify, and I'm going to answer any questions you have.
Thank you for your testimony, Mr. Reed. Are there questions for Mr. Reed? All right, seeing none, we thank you for being here today. And next I'll call on John Royce. Good morning, Mr. Rice. Go ahead.
Good morning. Good morning. Can you hear me?
We sure can. Go ahead.
All right. Thank you, Senator Sanborn and Representative Tepler and members of the committee. My name is John Royce from Augusta, and I represent the Maine Chiropractic Association. I'm speaking neither for nor against on both bills. I think that Mr. Robert Reed, the Executive Director of the Maine Chiropractic Association, did a very good job laying out the position of the Maine Chiropractic Association, so I really don't need to take too much more of your time. But I would like to express support for Senator Pouliot's amendment that does exempt the very small independent practices of which most chiropractic practices are here in the state of Maine. And I wanted to let you know that I will be attending the workshop. Thank you.
Great. Thank you, Mr. Royce. Thanks for being with us today. Are there questions for Mr. Royce? All right, seeing none, we thank you for your testimony. And next I will call on Bruce Garrity. Good morning, Mr. Garrity. Go ahead.
Good morning, Senator. Senator Sanborn, Representative Tepler, members of the committee. My name is Bruce Garrity, and I was planning on speaking only for the Maine Automobile Dealers Association, but based on some of the testimony you've received, I will also be speaking for the American Property Casualty Insurance Association. I apologize if I look like I'm squinting, but it's a brilliantly sunny day, and the way I'm set up here, I look right past the screen out into the backyard. So I don't have the dog barking issue, but I sometimes have the sunshine issue. Senator Sanborn, on behalf of the Maine Automobile Dealers Association, we have a multiple employer welfare arrangement, which I briefly discussed when we had our introductory session. That is a self-insured health plan. There is no profit motive. We simply try to provide coverage for all of our members. It's a program that is authorized under federal law, and federal law also authorizes the state of Maine to regulate it through the Bureau of Insurance. We use Anthem as our third-party provider to provide various claims and other services. And the only point I wanted to impart is that we have not seen complaints. We have not heard complaints from our members. Our members feel very free about calling us. It is a closed group. You have to be an employee of an auto dealer, and dealers themselves and their employees feel free to call the association. So I just wanted to provide that information for the committee. With respect to, pardon me, APCIA, they deal with both homeowners and auto claims, including automobile med pay claims, which is a subject this committee has addressed in the last session or two. Those payments are made right away when someone has a MedPay claim because it has nothing to do with liability. It's called a first party claim. Someone says they were injured in an accident. Under their own policy, they're entitled to whatever they purchased for a coverage limit, and they get it. Now, sometimes there ends up being a problem after the fact with a healthcare provider because the individual perhaps got the money themselves, didn't automatically send it on to the healthcare provider, said they wanted the money themselves. They are the actual policyholder, not the insurance provider. So at times that can occur, but that's outside the hands of a property casualty carrier. So I just wanted to provide that information as well, Senator, and I'd be happy to try and answer any questions the committee might have.
Thank you, Mr. Garrity. Are there questions for Mr. Garrity? All right. Seeing none, thank you for providing testimony today. That is the end of my list of pre-signed up folks to testify in either of the two hearings this morning. So if you're in the room and wish to testify on the bills that we're hearing right now, please do raise your hand before I close the hearing. And seeing no hands raised Representative Tepler, go ahead.
Thank you, Madam Chair. And I just wanted to ask our analysts that if there is any data available from the MHDO or any other organization that will help us with determining where some of the finger pointing that is happening, where the responsibility actually lays, that would be great to have for the work session.
Great. Okay. I do see a hand has gone up. I will invite Christine Austin-Fort to join us to testify in this hearing. Good morning, Ms. Austin-Fort. Go ahead.
Good morning, and thank you, Senator Sanborn, Representative Tepler, and members of the Health Coverage Insurance and Financial Services Committee. My name is Christine Austin-Fort. I am the Senior Government Relations Director for Anthem Blue Cross and Blue Shield here in Maine, and I am a resident of Portland. We're not really taking a position on this bill, but I did want to at least sort of weigh in and provide the committee with some additional information, much of which I'm sure your analysts will probably provide to you at your work session as well. But there are a number of provisions, both in the insurance code and that address this. I mean, we do have timely claim submission requirements for professional services. They generally are 90 days. A claim must be submitted to us within 90 days. For facilities, they are 90 to 180 days, depending on the contract. You know, we are trying to move to shorter time periods, but obviously contracts have to be renewed, and those provisions are often negotiated. There are exceptions, of course, as have been discussed. Coordination of benefits under Bureau of Insurance Rule Chapter 790, timely claim submission requirements are extended by 120 days if there are coordination of benefits issues to address the types of situations that have been described. We also have timely claim payment requirements. We must pay a claim within 30 days or else we have to pay interest. So we definitely have incentives to provide payment, to process the claims and adjudicate the claims. Typically, an explanation of benefit is generated when the claim is adjudicated. So as Representative Matheson noted, when we process that claim and the member gets the EOB, the provider is also getting the remittance information. It may not be simultaneous, but it is provided in a timely fashion. And there were suggestions that this provision should be moved from Title 22 to Title 24A. I think there's been a lot of testimony that makes this sound like it's an insurance issue and only an insurance issue, or only an issue for insured patients. I can tell you that I myself have experienced this with an automobile accident where I asked not to have my health insurance billed because I knew that the other driver was at fault. I settled with the insurance company and I didn't get the bill from my provider's office until like 7 months after the accident and I'd already settled the claim. So I would just suggest that this is not unique to insured individuals. And Representative Tepler, I think you received the answer to your question, but you are correct that if we are the policy in force at the time the services are rendered, the claim is our responsibility if it is a covered service and there are no other issues. There are times where we do request more information, and there are times when providers are put on prepayment review. Generally, it's because there are billing issues associated with the provider. There are times when the claim is changed because we feel it has not been billed correctly. So I think it is possible to incorporate sort of extenuating circumstances if the committee is interested in moving forward with the legislation. With that, I'd be happy to answer any questions, and I will be, of course, at your work session as well.
Thank you, Ms. Ossenfort. Are there any questions for Ms. Ossenfort? Okay, and I do appreciate you testifying today since there was much discussion about carriers, but no carriers were initially on our list to testify. So thank you for
We're not
raising your
directly
hand.
affected, but sometimes, you know.
Yeah, it is helpful to make sure that we get your perspective in the hearing nonetheless, though. So thank you for staying. I don't see any other hands up, so I'm going to call going once, going twice before I close this hearing on LD 167 and 367. So with that, the hearing is closed. And we're just going to take about a 4-minute break, and we're going to return at 11:30 to begin our next public hearing, which will be on LD 172. So if Christian, if you could let Representative Craven know that we'll be turning to her bill next, that would be great. All right, and Representative Tepler is going to run the next hearing, so we'll see you in just about 4 minutes.
I'm going to ask the committee members to please come back into our virtual committee room. Thanks everyone for rejoining us for a continuation of the public hearings before the Health Coverage Insurance and Financial Services Committee this morning. And with that, I will ask Representative Quint to introduce herself since she was not on the video as we began. So Representative Quint, please.
Thank you. My name is Tracy Quint. I serve House District 144, which is the Greater Holton area.
Thank you, Representative Quint. And now we're going to open a public hearing on LD 172, an act to improve prescription information access. And it's sponsored by Representative Margaret Craven. Representative Craven, are you ready to join us, I hope?
They're finishing up a roll call on HHS right now.
Ah, okay.
I think we can just wait for a moment. If they're in a roll call, we could probably just wait a minute, I would suggest.
Yes. Okay, so committee members, please just hang around, and anyone who's listening in, know that we're just taking a break while we wait for the sponsor of our bill.
All right, it looks like Representative Craven has joined us.
Yes, indeed. Thank you for joining us, Representative Craven. Please turn on your video and your audio so that we can hear from you and you can introduce LD 172. Representative Craven, are you there? Christian, we probably need your help here. Thank you.
I'm going for it.
Just letting members of the public know that we're trying to be certain that our sponsor is available to testify on LD 172. Yep, she dropped out again. So I'm wondering if we should consider taking, since Representative Cuddy is with us currently, if we should consider taking up LD 178.
Yep, I think that's fine. We can have Senator Stewart introduce himself, and then we'll see if Representative Craven has rejoined us. And if not, we'll move on to 178 and move back to 172 when Representative Craven's around.
Looks like I'm just in time. So thank you, Madam Chair.
Please introduce yourself, Senator Stewart.
All right, I am Trey Stewart, State Senator in District 251 communities in Southern Aroostook and Northern Penobscot, including the town of Westfield, which you pass through as you enter the Star City.
Thank you very much, Senator Stewart, and welcome. And Christian, can you let us know where we are with Representative Craven?
She has not jumped back on the call yet.
Okay, so we will then move to LD 178. And Senator Sanborn, do you want me to proceed with this one? Okay, thank you. We're going to proceed with LD 178, an act to reduce waste of prescription medications. And this bill is sponsored by Representative Scott Cuddy of Winterport. Representative Cuddy, please join us in the committee room. Welcome, Representative Cuddy. Please, that's it. Take it away.
Thank you very much. This is my first time sponsoring a bill yet in this new format. And I think your committee clerk has done a great job keeping things moving along. I appreciate it. Well, thank you very much, Senator Sanborn, Representative Tepler, and members of the Joint Standing Committee on Health Coverage Insurance and Financial Services. My name is Scott Cuddy. I live in Winterport, Maine, and I'm here today to speak in support of LD 178, an act to reduce the waste of prescription medicine. I'm also glad to see so many members of other committees that I serve on, Representative Morris and Senator Stewart. So this bill was an idea that came to me from a constituent. When during times when we're not in session, I often will call around to my district and just sort of check in with people and see how they're doing. And I spoke with a woman who had received a number of medications, and during the time of the initial prescription, there were a lot of changes. She wound up with a pile of pills that she didn't need. Either the dosage had been wrong and those pills couldn't be used for the new dosage, or the medication itself wasn't effective. And she just suggested to me, if I had only had a 30-day prescription of each one of these beforehand, I wouldn't have nearly the amount of pills that I have now. And also, my insurance company would have been charged for 90-day supply, where even though it's cheaper on a per pill basis, there's still a larger upfront cost. So none of that would have been necessary. And I thought, well, that's simple. That's an elegantly simple solution. You just limit it to 30 days, as she suggested. What could possibly be wrong with that? But of course, anybody who has been in the legislature for any period of time or been around the legislature knows that when you think to yourself, it's simple, what could possibly be wrong? You need to check yourself, because something is going to be wrong with it. I received outreach from a number of different stakeholders. No one that reached out to me was in direct opposition to the bill. They sort of supported the idea of reducing waste, reducing cost, but there were a number of things that came forward as possible problems. Planned Parenthood, AARP of Maine, Legal Services for the Elderly, and several state agencies all contacted me with issues and possible problems. And AARP was very good about digging up some great information around the bill. And I still strongly believe there's some merit to the idea of limiting prescription, the time period of prescriptions, but there are some significant problems with it as well. And I am I guess I'm as close to being neither for nor against the bill that I'm supporting as I've ever been, which is an odd place to be. But I am interested in working with the committee and stakeholders moving forward to see if there's a place where we can improve outcomes for patients without causing problems for others. So I am glad to be before your committee presenting this today. I am happy to take any questions that you may have for me. But I just wanted to lay out sort of how my thoughts on the bill have changed as I've learned more going along. So thank you very much.
Thank you very much, Representative Cuddy. Thank you for your honest and clear testimony, and also thank you for your praise for our clerk, who we also think is pretty awesome. And I'm looking to see if there are any questions from the committee. Yes, there is one. Representative Matheson, please go ahead.
Thank you, Madam Chair. Thank you, Representative Cuddy. If I understand you right, one of your primary goals for this bill was to try to reduce prescription waste. Is that correct? And also financial issues that your constituent ran into with getting these prescriptions? I just want to make sure I'm clear about the intent.
Yeah, the intent was to reduce the level of waste in initial prescriptions, because it would only apply to the initial prescription. Thereafter, it could be prescribed for a longer period of time. And the cost was more of a systemic cost. My particular constituent had a fee that she paid for the pills, whether it was a 30-day or 90-day. Her out-of-pocket was basically the same, as I understood it. But there's still going to be a larger cost to the insurance company, or to whomever is paying for, or a self-insured company, whomever's paying for the pills, because a 90-day prescription, even though it might be less per pill, is still going to be a bigger upfront cost for the provider than a 30-day prescription would be.
Do you wish to follow up, Representative Matheson? Okay. Thank you. And seeing no other questions, thank you for your testimony, Representative Cuddy. And I have no one else on the list speaking in favor of the bill. And in opposition, is there anyone out there on our panel of attendees who wishes to testify in favor of the bill? Okay, seeing none, I will go to opponents of the bill, and we'll ask Pam Cahill to please join us. Ms. Cahill?
Hi there. I'm here. I'm here. Do you hear me now? Give me a minute. This is my first time testifying in this new format too. So, and sometimes IT stuff is my nemesis. My name is Pam Cahill, and I'm glad to be here today, Senator Sandborn, Representative Tepler, and members of the committee. I'm a partner at Howe, Cahill and Company. We testify before the legislature frequently and in this committee frequently for a number of clients. Today, I'm here on behalf of the Maine Nurse Practitioner Association. I serve also as their executive director. Currently, there are 2,025 nurse practitioners actively licensed and working here in Maine in a variety of healthcare practice environments and all through the state, of course. NPs are independent practitioners with prescriptive authority, and including scheduled drugs 1 through 5. MNPA opposes the bill, and I am glad to hear that Representative Cuddy's explanation for the bill, because I think it was well intentioned. But we're opposed because it inappropriately puts limitations on the way nurse practitioners and other providers prescribe their medications. All prescribers have the responsibility to prescribe medications appropriately. Gosh, I can't speak. Putting restrictions on new prescriptions interferes with the patient-provider relationship and could be potentially dangerous. All patients have the right, according to the practitioners that I talk to, of requesting a smaller doses of pills. They can ask for a 15-day prescription. They can ask for a 30-day prescription. And they sometimes do that. But by mandating that they can only have a 30-day prescription is problematic for many because a lot of people prefer to go to a mail order type prescription because it's less expensive and it doesn't interfere with their copays. So healthcare, particularly in these times, is very it's a constant struggle. Patients are faced with issues such as transportation and access, not to mention their ability to pay for the prescriptions. So as healthcare providers, MPs oppose wasteful prescribing practices. We're happy to talk further with the committee and Representative Cuddy about that. But the decision of what medications and how much should be left to the patient and the provider. So on that, I guess that's all I want to say about this. I think the bill was well intended. I did want to make one comment at the very end of the bill in the summary, and we all know that the summary is not part of the actual legislation, but it refers to RNs as prescribers. And I just want to make the point that RNs don't prescribe. Advanced practice registered nurses prescribe. I just wanted to make that quick point. So I'd be happy to answer any questions.
Thank you, Ms. Cahill. Any questions from the committee for Ms. Cahill? Seeing none, thank you for your testimony, Ms. Cahill. And we'll move on to other opponents of the bill. Ms. Calder. Can you rejoin us?
I think I'm with you.
You are.
Okay. Senator Sanborn, Representative Tepler, members of the committee. I'm going to introduce myself this time because I failed to do so in the last hearing. It's very unsettling to have your computer shut down or look like it's shutting down. So I'm Sarah Calder. I'm the Director of Government Affairs at Maine Health. I will not belabor the point, but I just wanted to point out one thing. So the legislation before you today, I believe, does not allow for refills beyond the initial 30-day supply, which is something that our providers were very concerned with. And then there's also no definition of a new prescription in this legislation. So it's unclear if this applies to patients that have been prescribed a medication for years, but they're simply switching providers, or perhaps they moved to Maine from out of state. And so with those two questions in mind, limiting prescriptions to 30 days is a barrier to patients and providers trying to appropriately manage chronic disease, and it may even result in a gap in medical care. We do have a clinical advocacy committee within Maine Health, which is made up of clinicians throughout the system. And when I brought this bill before them for their input, they did say that in most cases, they don't initiate any medications that require a follow-up visit in 1 month. So they'll often schedule a follow-up visit within 3 months just to see how the patient is doing with the medication, if it's meeting their treatment goals. And then also during that initial visit, prescribers will ask how they want their medication prescribed. And Ms. Cahill mentioned this, do they want it filled by a brick and mortar pharmacy or through the mail? If they'd prefer a 1 month or a 3 month supply. And as you can imagine, patients have strong preferences on both of these options, really depending on their insurance coverage, co-payments, and other medications. And so I would also mention, and I think this was alluded to, that some insurers have incentives in place to prescribe a 3 month supply over a 30-day supply, which will cost the patient less. Wanted to highlight a few examples of new prescriptions that could be impacted by this legislation: diabetes medication, asthma inhalers, antiplatelet agents, and all of these could have really serious consequences on the patient's treatment if they weren't able to receive more than a 30-day supply. So for those reasons, Maine Health is opposing this legislation, and I would be happy to answer any questions that you may have.
Thank you, Ms. Calder. Any questions from the committee for Ms. Calder? I have one quick question for you that's procedural, Ms. Calder. Can you see the whole committee?
I can see the whole committee, yes.
Okay, great, thank you. That's just a question that had come up.
Oh, okay. All
in
right.
other committees.
I will say that my camera is above me, so if I'm not looking at you, it's because I don't know where to look, but so challenges of today.
You are doing fine, thank you.
right, thank you.
Okay, seeing no questions from the committee, I will move on to others in opposition. And we'll ask Ms. Robinson to please join us.
Thank you, Representative Tepler, members of the committee. Again, I'm Ann Robinson on behalf of Spectrum Healthcare Partners, once again, which, as I said, is a multi-specialty physician practice group here in Maine. And I guess I'm repeating the point, but that this bill does take a really broad brush, approach to medication and would apply to medications, some medications that by their very nature need to be, or at least are best prescribed for initial periods that are longer than 30 days. And some of those medications are ones that are well tolerated, expected to be taken for longer than a month, and require no laboratory or symptom monitoring. And so forcing patients to come back at the end of the 30-day period just increases the likelihood that, that they won't get back there in time and miss, prophylaxis treatment regimen. Other prescriptions need to be prescribed for longer than 30 days, but are not expected to be chronic. For example, a steroid prescription that's tapered over a 6 to 8 week period. So again, forcing the patient to come back at the end of 30 days to visit the prescriber again at that point really serves no clinical purpose and just ends up increasing the cost and again, increasing the chance that the patient won't get there in time and will, as a result, adversely affect the protocol for that medication. So with that, I'll close. Happy to answer questions. Thank you for the opportunity to be before you.
Thank you, Ms. Robinson. Any questions for Ms. Robinson from the committee? Seeing none, we appreciate your testimony, Ms. Robinson. And I will, before I turn to neither for nor against testimony, I will ask if there's anyone else who is in attendance who would like to testify in opposition. And I see Mr. Moran has his hand up, so we'll hear from Mr. Moran.
Good morning, Representative Tepler, Senator Sanborn in absentia, and members of the Standing Committee on Health Coverage, Insurance, and Financial Services. My name is Dan Moran, Director of Communications and Government Affairs. You should have my testimony. It was submitted quite close to the deadline, but it should be there. If not, you'll get it. I won't go over who the Medical Association is again, but we oppose this bill for the reasons listed on our testimony based on feedback from numerous physician practices. We had General Pediatrics get back to us and comment that they work with a patient population that doesn't always have an advocate for them in the house. It's a difficult thing from a broad perspective to take a look at, but pretty common at the ground level. Specialty peds clinics have many children who have diseases that might not be difficult from a medical physiological level, but extremely difficult to treat from a social resource medical level. And the ability to provide them more than 30 days of medication provides a convenience, but also maintains adherence to treatment for the patient who may be unable to advocate for themselves, being a pediatric patient. The reason why we say that is the MMA has been more focused than ever on healthcare disparities recently, including racial, ethnic, socioeconomic, demographic, and geographic. Some medications require an additional appointment. You just can't do a refill on the bottle or call up your prescriber. That brings up hidden disparities. If you don't live close to the provider, don't have access to transportation, or if you do have a vehicle, you may struggle to pay for your fuel, especially with the jobless rates increasing because of the pandemic. Nobody understands that more, for example, than Senator Stewart from the county. Another example we had where this bill would be complicated is a drug, levothyroxine. It's a thyroid drug, and that's one of those drugs, and there are many, but that's one of those drugs where you don't really know if the dosage is effective until you do lab results. And with an arbitrary 30-day prescription limitation, you know, you'd have to do another prescription because the results are best reviewed after 6 to 8 weeks in this particular condition. You know, we're going to repeat this often. Every medical diagnosis and medical treatment are different. There's also in my testimony a group of pediatric gastroenterologists who have 250 children, over 250 children with inflammatory bowel disease. It would present a problem. Medical formulas for inborn errors of metabolism is a problem. Those medical formula prescriptions aren't just for pediatrics, they're for patients that might be 5 weeks old or over 60 years old. And those patients are throughout Maine in every single county. There are also prescriptions that have to be changed based on growth, same medication, different dose. Would they have to redo the prior authorization process? Is that a new prescription if there's a different dose when a pediatric child needs a greater dose? And then one of the practices had an APRN colleague comment that mentioned something I didn't even think about, but a high turnover rate of primary care providers, even in Southern Maine, in some hospital systems. If your patients are stable on their medications for diabetes, hypertension, depression, it's already less expensive to get 90 days. But now if you switch to a provider because your provider left or you have a locum tenens provider, does that trigger the law if this passes? You can only do 30 days after you've been using 90 days for diabetes or hypertension for years. And we also oppose the restriction on pharmacists for a 30-day supply for, again, a mobile society. There are many people that receive prescriptions from multiple pharmacies. It may be a shopping preference, or they may have a pharmacy near work or near home, use 2 pharmacies. You might get your prescription at your pharmacy near work just because of convenience or whatever issue. But if it's a first prescription for that pharmacist, it would fall under this law and you wouldn't be able to receive a 90-day supply that you may have been receiving for years. So those are our comments. I'd be happy to take any questions back to our providers, our medical practices, and we will certainly be here for the virtual work session. Thank you.
Thank you, Mr. Moran. Any questions from the committee for Mr. Moran? Seeing none, thank you for your testimony. And I'll ask again if there's anyone else in opposition to this bill who would like to testify. Seeing none, I will move to the neither for nor against testimony. And first on my list is Mr. Delicata. Welcome, Mr. Delicata.
Thank you. Let me start my video.
That would be great.
Okay. I'm sorry that I haven't been following this meeting. I've been in judiciary, and I feel lucky that I've come at exactly the right time. I have written testimony. I don't know whether you're running a clock, but I have 3 points to make, and I'll go ahead and read them. Senator Sanborn, Representative Tepler, and members of the Joint Standing Committee on Health Coverage, Insurance, and Financial Services. There are actually three points, and I don't know if anybody's made them before. So the first one is that there's a problem here with federal law. The CARES Act has a provision in it that essentially allows people to request from their plans a 90-day supply for the initial prescription. And I don't know, again, if anybody has mentioned this, but if you pass this statute, it will not supersede the federal law, because the statute that the proposal before you is essentially saying that the first 30-day prescription, the first prescription is a 30-day prescription. The rest of them can be more than 30 days. And the federal law is saying the first prescription can be up to 90 days at the person's request. So if you want to pass what's before you, it should at very least have an effective date clause that tracks the coronavirus CARES Act trigger. And that trigger only lasts until the pandemic federal emergency is ended. So the president will at some point say it's ended. And at that point, the effective date of this statute could in fact work. But the second concern that we have, and we'd like to bring to your attention, is really financial and logistical. We represent people who have problems with getting their prescriptions through the Medicare Part D plan or the Medicaid program. And some Part D plans will pay for a prescription for a 90-day supply that costs less than a 30-day supply. So these normally are the kinds of prescriptions that you commonly get for things like an irregular heartbeat or heartburn or diabetes. And this bill would essentially increase the cost of getting those drugs in the first prescription because you would have to get a more expensive 30-day supply rather than a 90-day supply. And the logistical piece is that it is difficult for a lot of our clients to get to the pharmacy. And that's why they like the 90-day supplies. Even expecting one more visit doesn't seem like a lot, but if you have transportation issues, if you don't have the money to hire somebody, if you don't have neighbors that you trust, if you're afraid of getting sick, going to the pharmacy, people don't go to the pharmacy to get drugs all the time if they're not ill. They go to get drugs that could help cure their illnesses. And especially now with this virus, it just presents another barrier, another challenge. And the last concern is probably one that Mr. Moran addressed, although I didn't hear what he said. And that is that the bill legislates how medicine must be prescribed. And it completely removes discretion from anyone with a license to prescribe medicine to determine how much of a particular drug would be best for their patient. And rarely has this been an area in which the legislature has thought it proper to intervene so completely. I mean, the only time in my memory is the initiative to control opiate drugs. And that was because of the public health dangers and societal harms that are caused by substance abuse. And even in that case, the remedies were crafted with many discussions with lots of interested parties. So we hope you proceed cautiously. Again, I'm sure you've heard good testimony in opposition, but I'm here to speak neither for nor against because there are some benefits and there are some burdens. We just hope that you proceed very carefully with this. Thank you.
Thank you, Christian. I'm sorry. Any questions from the committee for Mr. Delicata? Seeing none, thank you for your testimony, Mr. Delicata, and we will continue with neither for nor against testimony from Mr. Austin.
I don't see Mr. Austin on the call at the current moment.
Okay. Then we will move to Mr. Picard if he's on the call. Welcome, Mr. Picard.
How are you?
Hanging in there.
Good afternoon, Senator Sanborn, Representative Tepler, and members of the committee. I'm Curtis Picard with the Retail Association of Maine, representing our independent and chain pharmacy members on this bill, testifying neither for nor against. I certainly appreciate the discussion this morning, and truth be told, I had every intention of reaching out to Representative Cuddy before this bill was heard because we wanted to better understand the genesis of it, which is why we're testifying neither for nor against. And both Mr. Moran and Mr. Delicata both raised the points that we wanted to raise. In section 13786-E of the bill that talks about the impact of pharmacies and pharmacists on it, and our pharmacist members have told us what Mr. Moran did is that a pharmacist is not going to know if the patient has a prescription history with another pharmacy. So we wanted to raise that for the committee. And Mr. Delicata did a good job talking about the 90-day prescription allowance in the U.S. CARES Act as well. So I think you've had a great discussion this morning. I'm happy to answer any questions, but thank you for your time.
Thank you, Mr. Picard. Does anyone on the committee have any questions for Mr. Picard? Seeing none, thank you for your testimony. We'll go ahead and call the next person to testify neither for nor against, Ms. Deborah Hart.
Ms. Hart is also not on the call.
Ah, okay.
She and Curtis just sign up in tandem to represent the same folks.
Thank you. I can see that now. Thanks. Mr. Hollmeyer, however, I believe is on the call, and we'll ask him to come on over and give us his testimony, neither for nor against.
Good morning, everyone. Can you hear me? This is Sam. Excellent. Thank you, Chair Tepler, Chair Sanborn, members of the committee. My name is Sam Hollmeyer. I'm here on behalf of PCMA, which is Pharmaceutical Care Management Association, and we are here neither for nor against LD 178. PCMA is a national trade association representing pharmacy benefit managers, otherwise known as PBMs, which manage prescription drug benefits for large employers, health insurance carriers, labor trusts, government programs, and other payers. I don't have any written testimony for you today on LD 178 as we're trying to get a better understanding of what this bill is trying to accomplish. Having that said, we're more than happy to work with Representative Cuddy, the bill sponsor, and the committee to ensure that there are no unintended consequences of this bill. Our member companies have a variety of fraud, waste, and abuse protocols already in place to contain costs as well as keeping patients safe. Previously, someone did mention a concern of what is a new prescription, and we would like a better understanding of that as well. And that wraps up my testimony today. I'm happy to take any questions.
Thank you, Mr. Hollmeyer. Is there anyone on the committee who has a question for Mr. Hollmeyer? Ms. Quint, did you have a question? I mean, Representative Quint, I saw you lean forward and I just wasn't sure. No. No, Representative Quint doesn't seem to have a question. Thank you very much for your testimony, Mr. Hollmeyer. And that is the end of my list for folks testifying neither for nor against, but I'm happy to hear from anyone else among the attendees who would like to testify on LD 178, an act to reduce waste of prescription medications. Seeing none, I will bring the hearing to a close and we'll take a short break and we'll see if we can get some information about where HHS is. So perhaps our sponsor of LD 172 can come back and join us. So let's take a 5-minute break and we'll see you at 12:15, everyone. Thank you.
Representative Quint, while we have a moment, can you just tell me whether or not you're on campus? Yeah. Okay. Thank you.
Christian, were you able to reach Representative Craven?
So I reached out to the HHS clerk and she's not on that Zoom call either.
Okay.
I believe the House chair is calling her to let her know that we wanted to start at 12:15.
Okay, great. Thank you.
Just want folks to know that we're waiting to hear from the sponsor of the bill we have a hearing on.
Representative Tepler, were you able to reach her?
I don't have, I don't believe I have her phone number, but I will look and see.
Okay.
Do you want me to call? I do have it, or
That would be great, Representative Brooks. Thank
okay.
you.
Madam Chair, I do know we both left the previous committee together. She did leave a little bit before me and stated she had this previous engagement.
Yes, and I also understand from Christian that she was having some internet difficulty. So we'll have to see, but we'll see what Representative Brooks gets from her, and I will look and see if I can contact her.
Do we have a call-in number that could be used? I did get a hold of her, and if she could call in to give testimony, that would be helpful.
All of that information, the call-in and her participant ID and everything is going to be in that same email with the link. She just has to scroll down a little bit further, but she's welcome to do
I
that.
think she's having internet troubles, but I can go to my link and find that out.
Yeah, that'll work.
Thanks.
All right, I stepped away for a moment. Did we get an update?
Representative Brooks got her on the phone, and we're trying to relay information for her to call in because internet seems to be the issue.
I see. Okay,
That-
great.
That seems to be the problem. And so she can't even find her email to get in.
Okay, can we text her the phone number?
Well, I think Heidi's working on that right now. I mean,
Okay.
Representative Brooks, sorry.
Okay.
Yes, she's calling in now.
Great.
Thank you for your help, Representative Brooks.
Oh, sure. I'm going to call back. One moment. Yes, she's trying again.
Representative Brooks, I just sent you the phone number and then her webinar ID and passcode. She might need to use her personalized stuff. It might not let her in
Okay.
if she's using yours.
Okay. Okay, she should be on shortly.
Thank you, Representative Brooks, for your help.
Sure.
Ah, there we go. Okay. All right. Representative Craven, can you hear us? She is muted. See if I can unmute her. Uh-oh. Now she's disappeared. Oh, okay. All right, we're going to give this another couple of minutes, and if it doesn't work out, we're going to break for lunch, and then we'll circle back. But I do want to just see if we can get her to dial back in.
Chair Sanborn, what do you think if she talked on speakerphone over my cell phone that we'd be able to hear it?
Yeah, we probably would be able to hear it. Sure.
Okay,
Let's
we'll
give
try
it a try.
that. All right, one moment.
I like the creativity.
It's a good idea. And the other possibility is that she could maybe transmit her testimony to Representative Brooks, and Representative Brooks could testify for her if need be. Okay, we're going to try that.
Great. Thank you, Representative Brooks. Representative Craven, can you go ahead?
Thank you very much. I am so embarrassed. You are now going to hate my bill with all of the trouble I've caused you. My computer screen crashed, and I've been pretty stressed here. So thank you for waiting. Thank you for all of your patience and you know, effort to get me on. So good afternoon, Senator Sanborn, Representative Tepler, and members of the Health Coverage, Insurance, and Financial Services Committee. My name is Margaret Craven, and I represent House District 59, which is part of Lewiston. I'm pleased to be in front of you this afternoon to introduce LD 172, an act to improve prescription information access. The idea for this bill came to me as a request from a constituent, the Honorable Roger Fuller of Lewiston. Some of you know him very well. But what you may not know is that over the past 4 years, he's had major reconstructive surgery on both his eyes. He must now take 6 separate eye drops 6 times each day to maintain his eyesight. Roger is neither unique nor alone in his situation. Imagine being blind or visually impaired and reliant upon taking medication for your health, but you find yourself unable to read the small print label on your medication bottle, or in some cases, the print in several different bottles of similar size and shape. This bill would require what is known as a quick response, or QR, code on the prescription label that can be read by the camera on a smartphone so that a person can digitally access the information on the label and other additional information about their medication. When I brought this bill before your committee last session, there was some confusion about the QR codes, that they looked like scanners. They looked similar to Brookhaven, except that they're square, and that they're low vertical stripes, meaning that they would not take up very much room. I have included an example of the QR code at the end of my testimony, although it's much enlarged. As I mentioned, those codes can be read by the camera on a smartphone. Once the phone reads the code, it can display the prescription information in a more accessible text size for the individual to read, or for the phone speakers to read the prescription for the person. Last session, Governor Mills and the ARP announced Maine's designation as an age-friendly state. If we are, as a state, are to be designated as age-friendly, then this legislation should be a step in the right direction as our family, friends, and neighbors are in place. I thank the committee from the bottom bottom of my heart, really. Thank you for all of the effort that you've put into me being able to reach you today. And I'd be happy to answer any questions if you have any questions.
Thank you, Representative Craven. We heard your testimony loud and clear. Thanks to Representative Brooks, which we really appreciate. Are there any questions for Representative Craven from the committee? All right, seeing none, we thank you for bringing us this bill and certainly welcome you to hang on the line with Representative Brooks so you can listen in or to join us on the YouTube if you have access to the internet. With that, I would invite anyone who's in our committee Zoom who wishes to testify in favor of the bill to raise their hand, because I do see Mr. Fuller in our Zoom, but I don't have him on my testifier list. So if Mr. Fuller wishes to testify, if you could raise your hand. He did raise his hand. Good, excellent. So we'll bring you into the meeting. All right. The Honorable Mr. Fuller, please go ahead and testify if you wish. Mr. Fuller, can you unmute yourself?
There
we
go.
go.
Does that work?
It does. Go ahead.
Well, thank you so much. Senator Sanborn, Representative Tepler, friends, thank you for allowing me to give testimony today on LD 172, an act to improve prescription information access. I forwarded this testimony to your committee clerk. My name is Roger Fuller. I live at 36 Elliott Avenue in Lewiston, Maine. When the world is just too much with me, like when fleece-lined gloves are more about the fleecing, when the news is not about the facts, but about the screed, and when it feels like being over 70 is a recipe for cold storage, I like to think that I am part of a rather select group, the BIA VIP. Some illustrious persons share membership in this group, and I count myself lucky to be in their company. People such as Homer, who wrote a verse or two, Ray Charles, who is known to beat a great jazz rhythm, or even Aldous Huxley. Afternoon tea with him would be momentous. To be a member of the Blind and Visually Impaired Persons Group, BIA VIP, is no walk in the park. Most of the time we trip. But it is livable, and we learn to cope, and some of us do rather well. But one of the difficult things to understand, and maybe even more difficult to find ways to cope with, is a very small but immensely troubling reality. Many in the BIA VIP group community take eye drops, but you know that. Many in the BIA VIP community take several different eye drops several times a day, and you might know that. But all those drops all come from tiny little bottles in indistinguishable pastel colors with instructions written in 5-point font. Even sighted people can't read those labels. It's more like eye drop roulette with some pretty blinding consequences. However, adding a pharmacy-generated QR code to the container or to the box, or to the ever-present unreadable associated paperwork could bring light to the situation and help for many. A QR code is readable by a smartphone. The smartphone can then display or even read the content to the blind and visually impaired person, or any senior citizen, or any handicapped individual for that matter, who is challenged by unreadable type for the life-preserving medicines. This is not new technology. This is not hyperbole. This is using existing technology for a determined purpose. We live in Maine, and thank you for your service to this great state. I would love to be a part of the legislature again, but legal blindness and 14 eye surgeries have determined a different path for me. We live in Maine, the oldest state in the Union. As leaders, Can we do something to make life easier for such substantial portion of our population? Thank you very much for your time and consideration, and I'd love to answer any questions if I may.
Thank you very much, Mr. Fuller. Are there questions for Mr. Fuller? All right, we don't have any for you. We thank you for being here with us this afternoon, Mr. Fuller.
Thank you.
And thanks. And next, I will take any additional supporters. I don't see anyone I expect to testify in support in the list or have any pre-signups. Okay, seeing none, I'll move on to opponents. And the first person I have on my list is Mr. Picard, who is with us. So we'll have Mr. Picard join us. While we're getting Mr. Picard on board, I will note that we haven't heard from Representative Connor to introduce himself. Do you want to, Representative Connor?
Yes, thank you, Madam Chair. I appreciate that. My name is John Connor. I represent House District 58, which is part of Lewiston.
Thanks so much. Mr. Picard, go ahead.
Good afternoon again. I'm Curtis Picard with the Retail Association of Maine, resident of Topsom, and representing our both chain and independent pharmacies. We're here today to respectfully oppose LD 172. Last year, an identical bill was presented in LD 2116. We opposed that bill and the committee unanimously rejected the bill, but you sent a letter to the Maine Board of Pharmacy requesting that the board reach out to licensees about how they assist patients with visual impairments. Recently, the Maine Board of Pharmacy discussed a document to be shared with licensees about the best practices pharmacies and pharmacists can utilize in assisting visually impaired patients. The document includes some recommended best practices developed by the National Council of Disability. And in my written testimony that I submitted this morning, I included links to both that document and the actually two documents related from the National Council of Disability. Given these national consistent recommendations, we feel that LD 172 is unnecessary. We support patients having as much information as possible for the medications they are taking, and we do not think LD 172 is the best way to achieve that. I thank you for your time today, and I'm happy to answer any questions.
Thank you, Mr. Picard. Are there questions for Mr. Picard? All right, seeing none, we thank you for providing that testimony.
And I'll just mention, if you still have Deb Hart on your list, you can scratch her off. I'll get into the routine of doing that now.
Yeah, that's great. Thank you. Thanks. And next we'll hear from Mr. Hallmeyer.
Thank you, Madam Chair. Chair Sanborn, Chair Tepler, members of the committee. Again, my name is Sam Hallmeyer. I am here on behalf of PCMA, Pharmaceutical Care Management Association, and I'm here today to oppose LD 172 and act to improve prescription information access. Again, PCMA is the National Trade Association representing pharmacy benefit managers, otherwise known as PBMs. I appreciate the opportunity today to provide comment on LD 172, which again was introduced last year. This would require a scannable barcode that is used to direct a patient to additional information on the prescription bottle. I have a couple concerns here. The first one I want to share is related to the limited real estate that is currently on the prescription bottle. Any additional elements such as this barcode that would need to be added to the bottle would sacrifice critical information that is currently already required to be on there. Additionally, we are concerned that the language appears to be too specific to one product. PCMA's member companies have a variety of different products in the marketplace that provide prescription label information to individuals who are visually impaired, which this bill is set to address. If we do want to move forward, I'm happy to work with the bill sponsor and request that the language be expanded to include other products that are available in the marketplace that our member companies currently use. For these reasons that I just outlined, we would respectfully oppose 172. I thank you for the opportunity to provide feedback, and I'm happy to answer any questions.
Representative Brooks has a question. Go ahead, Representative Brooks.
Hi, Mr. Hallmeyer.
Hello.
And this might have been a question that Mr. Picard could have answered as well, but I was, with the possibilities of having a QR code on a prescription bottle, it could really open the door for a lot of people. We've heard about the Honorable Roger Fuller having several eye drops and having a visual impairment. But I also believe it would help other generations as well. That the millennials and others use the QR codes a lot, and they have the smartphones to be able to do that. And a lot of times the paperwork will get separated from the medication bottle, and it would be, I could just see it really revolutionizing the way that consumers are and patients are able to understand their medicine. So I would, and I know that with my retail pharmacist, they had told me that the independent pharmacist said that it could be done with no ill effect on the pharmacist, as far as where she was concerned, that it wouldn't cost her more. So I just didn't know if you had any thoughts on that.
Thank you, Representative Brooks, for the question. Again, we're not concerned of any cost implications here. It's more, again, the real estate that's available on the bottle, along with the other pieces of information that's required to be on there. That's how I would answer that piece. It's not our concern isn't due to cost, it's due to real estate.
Okay. Are there additional questions for Mr. Hollemeyer? All right, seeing none. Oh, Senate. Oh, there are questions. All right, hold on. Senator Brenner, go ahead.
Thank you so much, Madam Chair, and thank you so much, Mr. Hollemeyer. I'm wondering if there's any discussion at the industry level about putting all the information into a QR code and just keeping the minimum written information required on the bottle itself.
I'm not aware of any discussions, but I can happily take that back to our members to take a closer look at it and provide feedback on that piece or that question.
Thank you.
Mm-hmm.
Senator Stewart.
Thank you, Madam Chair, and thank you, Mr. Hollemeyer. Question for you or anybody, I guess, maybe behind you two. I'm not really sure who's best suited to answer this question, but presently, if someone is blind or visually impaired, what avenues, if any, exist for them to be able to still read their prescriptions as it reads now? Maybe not, and what I'm asking is, are there other ways that this could be possibly addressed by still getting the same information across that is already happening? And I don't know the answer to that.
Absolutely, yes. So thank you, Senator Stewart, for the question. To reiterate, the member companies I represent have a variety of products on the marketplace to address this solution. And I would suggest if this legislation were to move forward, I could work with the bill sponsor to expand just beyond the QR code to include those other products that our member companies currently utilize. That's how I would address that.
Mr. Hollemeyer, can you explain, you've mentioned those other products a couple of times now, but I don't think the committee knows what you're referencing. Can you expand on that?
Sure, I would be happy to gather all those various ways that can be done and share it with the committee so that everyone can take a look at it. I don't have them in front of me at this exact moment, but happy to share that with you all.
Okay. The other hands went down. Okay, so are there any additional questions for Mr. Hollemeyer? All right, seeing none, we thank you for your testimony. That is the end of my list of people who had signed up to testify in opposition to this bill, and I don't have anyone signed up to testify neither for nor against. Is there anyone else who wishes to testify before I close the hearing on LD 172? All right, seeing none, I will close the hearing. And let's see, it is right now 12:50. We do have work sessions this afternoon, and I expect that, I know my folks need to caucus as well as eat some lunch and take a little break. So I'm going to propose that we reconvene at 2 p.m., which should allow us time for the caucus as well as some food intake. And I actually think that this afternoon's work sessions may go rather quickly, so I think that should be fine to have a late start. Any comments or questions from the committee before we break? Okay, great. I will see folks. Yeah, Senator Stewart, go ahead.
Thanks. Just to echo that comment for the Republicans, just stay tuned by your phones real quick, and I'll give everybody a call. We'll huddle up as well before we break for lunch.
Right, and I'll just send a note to our team on our phones as well. All right, thanks everybody.
What do you need, Christian?
We're good. I got it in chat. Thank you, Senator
Oh, okay.
Sanborn. Representative Evans, I just want to let you know your camera's still on if you'd like to turn that off before you leave. You're muted as well, so I cannot hear what you're saying.
Yeah, I was trying to copy the link down that you had sent.
Gotcha.
Yeah. Where are we coming back? As far as our caucus, what are we using?
Senator Sanborn should be sending you a note with the link for the caucus meeting, and then we'll reconvene on the link I sent you this morning at 2 p.m.
Okay, got you. Thanks so much.
No, of course.
I could get used to this legislative time that's only a couple of minutes off of real time. It's an excellent innovation of the COVID era. I like it. It's working for me. All right, so we've got more than half the committee back. And so I am inclined to get started if that's okay with you, Ms. Representative Morris.
Yes, I know Senator Stewart was not going to be able to make it this afternoon, so.
Okay.
Yep.
All right, great. Okay, so our agenda for this afternoon is to have 3 work sessions. First, we are going to start with LD 41, which is the MHGO rule regarding prescription drug price data sets. And I'd like to invite Colleen, I guess, to sort of present the bill analysis, and then we're going to hear from Karen Lee Harrington and Jim Jones.
Okay, great. I'm going to share my screen. I did have a chance to email out to you the slides earlier today, so you should have an electronic copy in your email as well, but I'll share the screen here. And let me know if that, let's see, I'm going to try to make it bigger for you. How does that look in terms of size for everybody? Okay, great. I think as everybody knows, this LR is a resolve. This is the committee's review of a major substantive rule of the Maine Health Data Organization. The rule has to do with the reporting requirements related to prescription drug pricing. The original rule was adopted pursuant to routine technical rulemaking as a result of specific language that was included in the legislation enacted last session, which was LD 162. But in the language of that statute, the legislature required that any additional rulemaking be subject to major substantive rulemaking process, which allows the legislature an opportunity to review those rules before authorizing the agency to move forward with the language of the rule. So what you have before you in Rule Chapter 570 seeks to make some changes to the original rule. They have been provisionally adopted by MHGO. The changes in the rule are intended to clarify the requirements for reporting entities to ensure more uniform data submission and to streamline the data collection and validation process. So just briefly, this next slide summarizes for you the changes or the amendments that were made to the rule. There were some changes in definitions. They added a new definition of drug product family, and I think you're going to hear some more about that issue later. They included repackagers in the definition of manufacturer. They also revised the definition of pharmacy benefits manager to align with statutory definitions that have been enacted by the legislature. And then they also clarified in the definition of wholesale drug distributor that does not include wholesalers who do not actively distribute product in the state of Maine. Additionally, there were changes proposed in the rule related to the registration and submission requirements. So the amendment removed reporting dates for requirements for reporting in the first year of the rule, and also clarified the scope and due dates for how MHDO will provide notice to reporting entities for requesting more information about their pricing component data moving forward. The changes require MHDO to post a list of specific drug product families for which data may be requested on its website by February 15th annually, and also provides that MHDO may not request data from any individual manufacturers or wholesalers or other reporting entities any sooner than 30 days after listing that information on the website. The rule changes also consolidate the manufacturer's report into one consolidated report and make some changes to clarify the specific data elements that are to be included in the reports that are made by manufacturers, wholesale drug distributors, and pharmacy benefit managers. There were a few issues, as you might remember, when we had the public hearing on this bill. The Pharmaceutical Care Management Association reiterated some concerns that they had previously raised during the rulemaking process before the Maine Health Data Organization. One related to the authority in the rule for MHDO to request national level data rather than state level data related to pharmacy benefit managers. They had suggested that the scope of the information requested should be limited to state level data rather than national level data. They also suggested that instead of making the change to February in terms of the reporting requirements, that they be allowed to maintain the reporting date of April, which was used for the first year of reporting in 2020. The second issue relates to drug product families and the added definition of drug product family in the rule. Both representatives of the Association for Accessible Medicines and Pharma expressed concerns about adding that definition and the potential for capturing drug manufacturers that would not independently trigger any of the statutory reporting requirements. They also noted that requiring reporting from manufacturers of prescription drugs included in the same drug product family, but which do not actually meet either triggers in the statute, that MHDO would be penalizing a manufacturer based on pricing decisions of other companies or other factors that would be beyond their control. We don't yet have any of the fiscal information, but traditionally in the past, when we've reviewed rules like this or reviewed resolves related to major substantive rules, any fiscal impact has been minimal. I just wanted to briefly kind of in these last two slides run through with you and remind you that there are some criteria in the statute for the legislature to consider when you are reviewing a major substantive rule that's been presented to you from an agency. And this slide just lists for you in summary form what the statutory criteria are. The statute asks that the committee consider whether or not the agency has exceeded the scope of its statutory authority within the rule. They've asked whether the rule can ask yourself whether the rule conforms to the legislative intent of the statute that it implements. Consider whether or not the rule conflicts with other rules or laws. Consider whether the rule is necessary to accomplish the objectives of the law. Think about whether or not the rule is reasonable. Could it be made less complex or easier to understand? Was the rule proposed in compliance with requirements of the Administrative Procedures Act and other law? And I can tell you that the rule was adopted in accordance with the APA requirements. And then the last consideration is whether or not the rule significantly reduces property value. And if it does, is that reduction necessary or appropriate? And does the rule avoid an unconstitutional taking? And then finally, this last slide just outlines for you what your options are when you're considering making a recommendation or taking a vote on the rule before you. A vote of ought not to pass of the committee would authorize adoption of the rule with no changes. A vote of ought to pass as amended could take two forms. One, it could authorize adoption of the rule by specifying that certain changes must be made to the rule before MHDO can go forward with final adoption, or an ought to pass as amended recommendation could state that the legislature is not authorizing the agency to move forward with adoption of the rule. There is a little quirk in the statute as it's drafted that does require that the legislature make affirmative vote if the committee does not want the agency to move forward with the rule. So if the legislature failed to act, which would typically be reflected in an ought not to pass vote, that could have the effect and would have the effect of letting the agency move forward with the rule as proposed before you. So you don't want them to move forward with the rule in this form. The recommendation is that you vote ought to pass as amended. And the last thing I'll mention is the rule as it's drafted is an emergency. So it would allow the agency, if it's authorized to move forward either in its current form or with changes, to move forward quickly to finally adopt the rule. And I'll stop sharing now. I would note that you did receive some additional information that Christian just emailed right before the work session started, which is sort of some written comments from MHDO. But I know that Ms. Harrington and others are here and could kind of summarize that information for you. But if you're looking for that, that should be in your email as well.
Great. And I have taken the liberty of asking Karen Lee, Ms. Harrington, and her consultant that she's been working with to join us today so that they could present their memo back to us. And it is in your email at 1:50. If folks are working with two screens and want to pull that up.
I'm going to bring them into the meeting.
Yep, great. Thank you. So I thought it would be helpful. Some people are visual learners. Thought it would be helpful to have that, but also some people really are better with it presented orally. So we've got both. All right. So welcome, Ms. Harrington and Mr. Jones, if you guys could introduce yourselves, that would be great.
Great. Good morning. Good morning. Good afternoon, everybody. Karen Lee Harrington with the Maine Health Data Organization. And joining me here today is our consultant, Jim Jones, who's been working with us really since we started the routine technical drafting of our first rule. And I'll let Jim introduce himself, but I'll just say that we're very lucky to have his expertise, and he really has helped guide us through this process, and happy that he's able to join us today. Jim?
Thank you. Good afternoon. Yes, I've been in the consulting industry working with pharmaceutical companies and wholesalers, and so I have a background in technology that's been used for pricing and rebates. And as some of these transparency laws have come into effect, I've worked with a number of states, including California, in one of the first transparency bills to understand some of the data, the levels of information, and how best to go about collecting that information.
Great. So I guess I'm going to ask either of you to just sort of walk us through this memo. We've obviously just received it, so we hadn't had a chance to read through it yet. But if you could just summarize the issues I guess we'll start with the drug product family issue. And if you could help us understand that better, that'd be great. So I'll leave it up to the two of you how to divide that up.
Thank you, Senator. So I'm going to let Jim really talk about the substance of this issue, but I just want to make a couple of comments before we get into it. And I just want to remind everybody that the purpose of this law, when it was passed and when folks were working on it, was really about raising awareness for consumers around what goes into the pricing of drugs and how that impacts the supply chain and what are some of the alternatives. It was really, I've heard, I guess, during the public hearing, the statement that it's punitive, that the requirement to report based on triggers, and I'm sorry, my dog is barking. He's senior guy and he is just all of a sudden having a moment. I'm going to turn this over to Jim real quickly, but I just want to underscore that this isn't, maybe they see it as punitive because they have to report information to us, but that's not the design of it. The design of it is to be about transparency and giving us the information that we need to then turn around and share it with you and the public in terms of, what is going on in the supply chain. We do have a lot of limitations in terms of what we can and cannot report. So, there's some challenges there, but, this one particular topic is really important to us. And with that, I'm going to turn it over to Jim and let him talk you through the drug product family. And then I'll come back and talk about the two easier issues. But Jim, go ahead.
Sure. So as proposed, the drug product family, the new definition that we're introducing to Chapter 570 is that a drug product family is a group of one or more prescription drugs that share a unique generic description and drug form. And so what we're seeking to do is collect information not just from a manufacturer who might raise the price of a drug over 20%, but also to look for other alternatives in the marketplace that might be available if there are certain manufacturers that have higher prices than others. So by collecting the additional information around all of the indices or the drug products provided by all manufacturers in the space for one particular generic molecule is the industry term, and drug form, so that would be tablets or caplets or suspensions. By looking at one whole family, we're able to ascertain whether not only the WAC costs that are referred to throughout the law, but also the net costs. How are those impacted? The detailed information that we collect allows us to look at, again, not just the WAC cost that's already publicly available information, but revenues, the total number of units that are sold in the US, and the amount of rebates. And all of those can be used for us to figure out if there are lower cost alternatives available, and we can report that in our public annual report. And while we may not be able to get into the specific manufacturers, we can say that there are opportunities to reduce the cost of prescription drugs in Maine by looking for lower cost alternatives using the data that's available through the All Payer Claims database in combination with the data that we collect through this law. One example, and then I can stop and take any questions that I wanted to provide just so that there's a little bit more clarity around it, would be for a drug, the brand name is Suboxone. It's for helping in the opioid space and helping with addiction. And right now it's one of the higher priced drugs in the state of Maine. In the first 3 quarters of 2020, just looking through the All Payer Claims data, the spend in Maine was just under 35 million. For this drug family, there are 7 manufacturers that produce drugs. There are 11 distinct packages and sizes that go into this drug family. And so there are alternatives available in different price points. When we looked at the spread of WAC costs for just the most expensive of these items, the range is from $190 to just under $270. And that's at the WAC level, so before any rebates, before any pricing arrangements between contracting entities in the supply chain. So what we would be able to do in gathering the drug family information from all manufacturers that make that particular product is to ascertain how much are they actually selling the drug for. It's one thing to look at WAC, and it's commonly the first step and the first price in the supply chain is to sell to a wholesaler at WAC, but there are also contracts directly with pharmacies and buying groups that may be at less than WAC. So having the data from manufacturers that says, what is the total revenue and what is the total units sold, we can back into what they're selling, actually selling the product for. Further, we can look at the amount of rebates that are provided from the manufacturer to downstream supply chain entities and get a better idea of what the actual net cost of the drug is. So it may very well be that the highest priced drug is $270 if we look at WAC, but it could be that there are enough rebates that go back to the payers that it's actually one of the cheaper options. We wouldn't want to make a recommendation that public payers make a shift in how they procure drug products just based on WAC. And so by getting this additional information from manufacturers, we look for lower cost alternatives that we can report back to this committee.
Thank you, Mr. Jones. Yeah, I think it's really important that you mentioned the public payers and that that last piece of what you were explaining there, because I think that helps the committee, that some of the newer members of our committee might not know how this all kind of fits together, but we have this prescription drug affordability board that was passed as part of the same package that is designed to really be able to take some of this transparency data and use it for the benefit of our public payers, which means our state employee health plan, our university health plans, and any other health plans that are really paid for with taxpayer dollars. So there's a forum that they're already meeting in and have the ability to kind of make this data potentially actionable, but we have to give them the data that they would need to take action on. So thanks for highlighting that piece. Are there questions for Mr. Jones? All right, I don't see any. I will make a comment that I have asked Christian to send out to the interested parties list the MH deal memo that we just got about 10 minutes before this work session. So that has been sent out to the interested parties list just moments ago. And I apologize for that oversight, but just trying to work in real time here. Any other questions for Mr. Jones about drug product families? All right, seeing none, let's hear from Karen Lee on the other two issues that are addressed in the memo. You're on mute.
Can you hear me? Okay, so one of the other issues that was raised was the issue around collecting data from the PBMs at the national level or at the US level, which is the proposed change that we had made. And the comment was, can we go back to what it is currently, which is at the state level? And without getting into a whole lot of the discussion, because I know you have a lot of other work to do, I'll just say really quickly, we took that back and noodled it around. And we've concluded that we could, it probably in the end does make more sense for the PBMs, for some other analysis that we want to do that's state specific, to look at the PBMs at the state level. So we would suggest that that be a change that you make, and where it says US, and this would just be for the PBM reporting, it would revert back to, but we would ask that you explicitly put state of Maine because it was not specified, and it should be. And if no issue on that, I can move on to the last topic.
Are there any questions about the PBM data aspect of this? Okay, great. Then we'll have you move on to the last part.
So the last issue, and my apologies, I did want to try and put this into a timeline, and unfortunately the person on my team that knows how to do that had an issue, and I tried to figure it out and it was not happening. So I tried to put this into a table to sort of articulate what the action is and what the current timeline is and what we are proposing and why. So just real quickly, the requirement in the law is that MHDO needs to notify reporting entities of the specific NDCs that they have to report pricing component data back to us on by April 10th. That was the requirement in the first year. Okay, we're now into year 2 of this rule. So by next Monday, we are required to notify the reporting entities what NDCs they need to submit detailed data on. The law and the rule then have a requirement that pricing component data is due to us 60 days after MHDO makes that notification. So in the first year, the data was due June 10th. In the second year and each year thereafter, the way the rule is currently written, data is due April 15th. What we are proposing is that we make the posting of this information on our website on February 15th. And we give folks 30 days to take a look at that. And then after the 30-day period, we then send official formal notification to the reporting entities. And then they have 60 days. So the earliest that we would get the data would be May 15th. And the reason why we are requesting that we receive the data in May is because this gives us time to do the needed validation and analysis that we need to do in order to develop our annual report as required by statute. So what's being asked is that I believe that what is currently, or not currently, but in the first year, that people had until June. And we are proposing, we kind of split it, that it be May, where in the current version of the rule, it would be April in terms of the due date. So, you know, does another month make a huge difference? You know, it does when you have a small team and we've got things worked out. But if, you know, that's something that the committee feels strongly about, we could probably be flexible there. But our preference would be to leave it as it is proposed.
Thank you. And I had asked Ms. Harrington to lay that out because I think there was some confusion that the data was due in February under the proposed rule, which it's not. So just wanted to have her kind of clarify that piece. Okay, are there any questions for Ms. Harrington on that front? Someone's got their hand up. Representative Connor, your hand blends into their light behind your head.
Thank you, Madam Chair. I apologize for that. My other committee chair said the same thing. I think I'm going to have that light changed. Very quickly, I'm trying to look it up, the statute as well. When is the annual report due, Ms. Harrington?
So the annual report, if I'm remembering correctly, our first report is due in November. And we were delayed in the first year significantly by a number of factors. So we had let leadership know that we were going to be delayed, but going forward, we have every intention to hit the due dates.
Thank you. That is all I had, Madam Chairman.
Anybody else have any questions for Ms. Harrington or Mr. Jones? All right, great. So I am at this point, just to let everybody know where we are on this, I am planning to table this bill. We're not going to complete our work on this today There is a title coming that would impact this work, and there's just more discussion to be had around all of it. So I just wanted to set the table today with regard to drug product families, particularly, and be responsive on that front, and making sure that we understood the issue. But that is sort of as far as I had planned to go today, pending some other things that we will work on later in the session. Representative Tepler.
I was just going to make a motion when you're ready for it.
Yeah, is there any further conversation on the committee before we make a motion? All right, Representative Tepler, go ahead.
Motion to table the bill we're discussing, which is LD 41. And that's it.
Is there a second?
Second.
Representative Morris has seconded. It's been moved and seconded to table this. This is we can just do with a show of hands in your window. All in favor of tabling? Okay, so the bill is tabled and we'll close that work session and revisit it later as our work allows. Okay, so next we're going to open a work session on LD 60, an act to clarify the minimum amount of emergency refills of insulin. And I'll ask Colleen to share her bill analysis.
Okay. So here we go with LD 60. This was the bill that Representative Tepler sponsored and you discussed or had the hearing on Tuesday. Current law, which was enacted last session, authorizes a pharmacist to dispense emergency refills of insulin and any associated insulin-related supplies, and also requires that the amount of insulin that a pharmacist dispenses on an emergency basis must be in a quantity that is the lesser of a 30-day supply and the smallest available package. The bill before you, LD 60, makes a clarification to the existing provision. So, and it would require that the insulin dispensed be in a quantity that is at least a 30-day supply. As I mentioned, this provision was enacted into law by the 129th legislature. It was considered by the this committee last session. It was enacted on an emergency basis and became effective March 18th of 2020. There were two parts of the law that was enacted last session. The first part of the law had provisions related to health insurance carriers, and it prohibited health insurance carriers from imposing cost-sharing requirements for prescription insulin drugs in excess of $35 per prescription for a 30-day supply of insulin. And those requirements applied to all health insurance policies issued or renewed on or after January of 2021. So that provision just recently went into effect for health insurance policies in the 2021 plan year. But Part B of the law is the piece where a pharmacist was authorized to dispense emergency refills of insulin and associated supplies. And as I mentioned, the law required that the dispensing be in the lesser of a 30-day supply and the smallest available package. There were also provisions in the law enacted that require the Maine Board of Pharmacy to adopt any rules to establish adequate training requirements and protocols for the dispensing of insulin. You did have some issues that were raised in the testimony on this bill. One of the first issues that was raised by the testimony from Legal Services for the Elderly and also echoed in the testimony from the Retail Association of Maine suggested some concerns that there might be some clients or patients that may not want to pay out of pocket for a full 30-day supply of insulin. The Legal Services for the Elderly proposed an amendment that would require no less than a 30-day supply be dispensed to patients who have insurance coverage, but would allow dispensing of less than a 30-day supply to a patient who might be paying cash or directly out of pocket. The Retail Association, on behalf of their community pharmacies and the Maine Pharmacy Association, suggested again that patients may not want to a full 30-day supply due to either due to the increased costs, and also recommended building some flexibility into the language to allow patients upon their request to receive insulin in excess of the smallest available package, for instance. In thinking about it and thinking about, primarily the sponsor's intent behind the bill, I might suggest that, the committee think about possibly amending the language to require dispensing in at least a 30-day supply unless the patient requests a lesser quantity upon consultation with the pharmacist. I'm not sure that it's necessary to make a distinction, particularly in the provision in the current law as it stands, because the provision that we're talking about relates to the authority of pharmacists to distinguish between how the person pays for the insulin. So I don't think the distinction between someone having third-party coverage and someone being a cash paying patient necessarily matters, but I think you could get at that issue and provide the flexibility by possibly thinking about adding some language similar to what I've suggested, giving the patient the opportunity to request a lesser quantity. You also had some testimony from the Maine Osteopathic Association and the Maine Medical Association indicating their belief that the patient's healthcare provider should have some additional notice from the pharmacist when they provided an emergency refill of insulin. So they suggested that the committee consider adding a provision to the bill that might require the pharmacist to notify the healthcare provider that wrote the original prescription. There are provisions in the law now that require the patient, before the pharmacist issues the emergency refill, to provide some testify to or provide some information that they are in possession of a prescription for insulin. The Maine Health and the Maine Medical Association also suggested that the committee might consider adding a limitation on how many dispensing of emergency supplies of insulin a patient might receive per year. They suggested possibly limiting the dispensing to once per year. So you might consider adding that to the bill. And then, as we've discussed with some of the other prior legislation, you might consider moving forward the possibility of adding an emergency preamble and an emergency clause to the bill so that it would become effective once signed by the governor. As I mentioned, the original legislation was enacted by an emergency, with an emergency in the 129th legislature. Lastly, in terms of the fiscal information, we have gotten some information that demonstrates that the belief that any additional costs to the Board of Pharmacy to implement the requirements of the bill would be minor and could be absorbed within their existing budgeted resources. So I'll stop there and happy to answer any questions that the committee might have. And you also have folks in the room who could respond to any questions as well.
Thank you, Colleen. I had a, oh, now I've lost it because the text went away. I'm going to pull up the text. No, it's okay. I'm going to pull up the text on my second screen here, and I'll just ask if the committee has any questions.
I can pull up anything too if you want to look at the current law, or I have that ready to go too.
Okay. Does the committee have questions? Representative Arford.
Just a quick question. It's my understanding that with the exception of controlled substances, there is no statewide registry, so that one pharmacist like in Brunswick, if someone went up to Waterville, would know if they were actually doing, receiving an emergency supply of insulin. At those two, there would be no way of communicating between the two pharmacies. Is that correct?
Colleen, do you have an answer to that, or we could also ask?
Yeah, I mean, I think we did talk about that a little bit last time. I'm just looking quickly. I don't think any of the representatives in the Board of Pharmacy are in the room quickly that I can see, but I think you might be right, Representative Arford, about, the extent to which all pharmacists would be linked in terms of getting access to that information. So I could definitely follow up and get you some more information about that. I think there is language in the statute, related to the pharmacist being asked to sort of verify and get some information from the patient that they have a prescription that is in place. And so they can ask for some background or follow-up information or documentation from the individual requesting the emergency refill to kind of affirm at that time that they are in possession of a valid prescription, but for circumstances beyond their control, it's on a weekend or the like, they're not able to get that prescription filled. So that's why the emergency dispensing is permitted.
Right, not able to get it renewed, I think. So it's an expired prescription, I think is the intent. Yeah. Representative Tepler.
Thank you. I also want to add that if we decide to add the provision that the pharmacist should get in touch with the prescriber to verify an ongoing prescription, that should take care of any question of people going from pharmacy to pharmacy to get insulin. So, I really don't think that in terms of this life-saving issue that we need to worry that much about people going from pharmacy to pharmacy, particularly if we add that provision.
Can I just say,
Representative Arford, go ahead.
It was my concern is not that people would go from pharmacy to pharmacy. The point I actually wanted to make, and I'm still learning the rules of how to do this back and forth, but is that I don't know if it's actually necessary to limit it to one time annually, because I don't really think many people will be doing that. I think in most cases, this will be a true emergency and they won't want to have to go through that process again. So I was getting to the point of there'd be no way to enforce it anyhow. So maybe we want to think about not putting that in there.
Right. Great. We're on the same page with that regard. I don't want to put a 1-year rule in there either. Representative Connor.
Yes, thank you, Madam Chair. I tend to lean in favor of all this bill, especially with all of these recommended changes. My question was, as Representative Arford, mentioned the once per year. I was curious how that would be implemented. Who would have the onus of managing that, and then what would be the oversight for that? So I don't understand. I understand the reasoning behind wanting just a one time or one per year, but I think the logistics behind it and the reasoning behind it probably just don't add up. So I would be okay if that was stricken.
Yeah, I'm on the same page with that as well. And I know our crew is on that page as well, because not so much the logistics of implementing it, but the possibility that someone might arrive in December and be turned away and then die, which is not something we want to see happen, and is precisely the opposite of what the purpose of the bill is. Representative Evans.
Thank you, Madam Chair. I agree with what's been said before.
Representative Evans, we can't hear you when your video is on, so it may make sense for you as a matter of course to turn your video off when you speak, because we cannot hear you when you have your video on.
Can you hear me now?
Much better.
Okay, I'm going to go to another room.
Okay. All right. Did you want to ask your question?
I'm unmuted.
Yep, go ahead.
My point was the issue of the pharmacist notifying the primary care physician or whoever wrote the prescription. That's an important step that should not be omitted, because it could be a signal that that person is not taking the medication as prescribed.
Yep.
Depending on, so I think that's critical to keep that in.
Yep, to put it in. I think actually it's not there, but we would be looking at adding that in. And I remembered what my question was, Colleen, which was whether the Board of Pharmacy has initiated rulemaking with regard to training requirements and protocols.
They have not yet, no.
Okay. Does that mean that the law isn't in effect yet? Or is it permitted for pharmacists to dispense now on an emergency basis without those rules being in effect?
I believe that the law would allow it to happen now in the absence of the rules. Yeah, there was no specific requirement in the statute that they couldn't do it.
Okay. So I think in that case, I would ask that the language, when we go to make a motion, that the language regarding notification of the provider who wrote the original prescription be added to the text of the statute. I was going to suggest that it could be put in the rule, but I think if the rulemaking may not happen or may be delayed, we just want to put it right in the statute.
Yeah, I think you could do both. You know, you could put it in the statute and then sort of authorize additional, you know, rules to sort of develop the process. I mean, one issue about that might arise as a pharmacist may not have information on hand to identify who the practitioner is unless it's provided by the patient. And there may be, you know, so they're going to be relying on some of that information, you know, so you might want to build in some requirement, notify the provider that, you know, was indicated by the patient at the time, you know, to be notified or something like that. Yeah.
Yep. Representative Tepler.
Yeah, I was just wondering that given that the rulemaking appears not to have begun, even though I recognize that with the pandemic, rulemaking processes may be especially delayed, I'm wondering, do we want to put a date in to encourage that? Just a thought.
My sense would be as long as the substance can happen, you know, the emergency prescribing can happen so that folks are not being turned away at the pharmacy counter, that I'm fine with that, given the reality of the rulemaking process and how slow it can be in normal times.
And I'll follow up too to get, you know, assuming the committee moves forward with a vote, you know, in drafting the language, I'll consult with the Maine Board of Pharmacy.
Great. Are there any other members of the committee that want to make a comment on LD 6D before I entertain a motion? Representative Connor.
Thank you, Madam Chair. I just wanted to go back. I believe somebody had mentioned talking about having the pharmacist reach out and contact the primary care physician, and I thought I heard some mention of it would only be able to happen if the member actually gave that information to the pharmacist. Isn't it required, as the statute is written, that this can only happen if the member shows evidence of a previous prescription? So doesn't that pretty much nullify that? I just want to make sure I heard that correctly and I had it all correct.
Yes, the language of the statute does require that, but it doesn't require that necessarily that they ask for the emergency refill from the pharmacy that normally fills their prescription, if you understand what I mean. So there could be an opportunity where they might go to a different pharmacy and they might not have that information readily available, was what the point that I was trying to think about.
But showing the empty, you know, container, it would likely have the prescriber's name on it. And then that would be evidence of a prior prescription as well as the information necessary for the contact.
Yeah.
Senator Brenner, did you have a comment?
I was just thinking back to our morning, it could have a QR code.
Could. Not right now, but it could in the future. All right. Anything else? All right. So with that, I would entertain a motion on LD 60 if somebody wants to try and capture the changes that we've discussed. Representative Tepler, do you want to try and do that, or do you want me to do that?
I think I'd be happy to do that. I just
Go for
wasn't sure if that was the right role. So I will
Go
be
for
happy
it.
to do that. So I will move ought to pass as amended on LD 60 with the amendments including the come on, Denise. The notification of the prescriber by the pharmacist and a request for a renewal of prescription. And the other thing that we wanted to add, help me out, please, here, Heather.
The language in the first paragraph, at the end of the first paragraph of Colleen's bill analysis that says, unless the patient requests a lesser quantity upon consultation with the pharmacist.
Yes, so that people will be able to receive lesser quantities if they choose to do that, either for financial reasons or just because they don't need that much insulin until their prescription is renewed.
Okay, so it's been moved. Is there a second?
Second.
Representative Connor seconds the motion. And this does need to be taken by a roll call. So if the committee is ready for the question, I'll have the clerk call the roll.
Before you do that, can I ask one question? You talked about a timeline potentially for the rules, but I wondered if you wanted to add an emergency or not, so it would go into effect or not.
That was on here as well.
I didn't know if you wanted to consider that or talk about that.
I think we should add an emergency clause. I'm seeing nodding. I'm looking for Representative Connor to nod, who seconded the motion. Yeah, so we'll take the friendly amendment and add an emergency clause. Just raise your hand if you object to that. Okay, seeing none, let's amend the motion to include the emergency clause. Great.
Thank you.
Okay, so now we're ready to call the vote, and I'll ask Christian to go forward.
Motion is ought to pass as amended on LD 60. Representative Quint.
Yes.
Representative Quint ought to pass as amended. Representative Connor.
Yes.
Representative Connor ought to pass as amended. Representative Blyer.
Yes.
Representative Blyer ought to pass as amended. Representative Morris.
Yes.
Representative Morris ought to pass as amended. Representative Matheson.
Yes.
Representative Matheson ought to pass as amended. Representative Evans, we'll need you to turn your camera on. Representative Evans.
Well, we can come back to him.
Representative Arford.
Yes. As
Representative Arford ought to pass as amended. Representative Melorano.
Yes.
Representative Melorano ought to pass as amended. Representative Brooks.
Yes.
Representative Brooks ought to pass as amended. Senator Stewart is absent. Senator Brenner.
Yes.
Senator Brenner ought to pass as amended. Representative Tepler.
Yes.
Representative Tepler ought to pass as amended. Senator Sanborn.
Yes.
Senator Sanborn ought to pass as amended. And Representative Evans, are you there?
Yes.
Can you turn on your camera, please? Now, can you say yes?
There we go.
I hope. Yes.
Representative Evans ought to pass
Good job.
as amended. Thank you.
All right. Okay, great work, committee. Next, I will open a work session on LD 224 and ask Colleen to walk us through the bill analysis.
Okay, so LD 224. This was a bill also sponsored by Representative Tepler on behalf of Bureau of Financial Institutions. It's an act to modify requirements for multiple party accounts, limited purpose financial institutions, and mergers. There are 6 sections of the bill, and just this summary summarizes each of the sections. Sections 1 and 3 of the bill would authorize mutual holding companies organized under the laws of this state to acquire by merger a federal mutual financial institution or other state mutual financial institutions under certain conditions. Section 2 of the bill removes some inconsistent language in the statute that require a signature card or other document establishing a multiple party account to provide notice to the depositor that on the depositor's death, the balance in the account will belong to the surviving party. The bill retains in law the requirement that when a multiple party account is established, the parties establishing the account must indicate in writing their intent as to whether or not the balance in the account will belong to the surviving party on the depositor's death. Committee members who served in the 129th legislature and the 128th legislature will remember that this issue has been discussed a number of times, and there have been a couple of fixes or attempted fixes in the statute. And I think this is hopefully is the last one. There have been some changes to the main probate code in response to changes to the uniform probate code that do allow the establishment of multiple party accounts, and someone in doing so can make a determination at that time as to whether or not they want the balance in the account to belong to the surviving party on the depositor's death. So this section 2 would take out some of that inconsistent language about having a separate signature card or other document that would provide notice. And then sections 4, 5, and 6 of the bill require any new non-depository trust companies, merchant banks, and uninsured banks that would be authorized and organized under the laws of Maine to locate their principal offices in this state, to have one resident of the state at least on its governing board, and to hold at least one of its governing board meetings in the state. This would be a requirement that would be prospective only, so to the extent that there are any existing entities organized in this way in the state of Maine, these requirements wouldn't apply to them, but moving forward to it would apply to any new entities. The Bureau of Financial Institutions did suggest a technical amendment to the bill that would make some changes in sections 1 and 3, and you did receive this as part of their testimony. They worked with interested parties on this proposed language change, primarily the Maine Bankers Association. It's my understanding that all of the parties are in agreement with this suggested change. So you'll see highlighted there just a corresponding change in both section 1 and section 3, taking out the reference that was proposed in the bill to a state or federal mutual financial institution, and just spelling out specifically both mutual financial institution or mutual federal association in the statute, just to clarify that those and to reflect the sort of the specific legal language and the legal structure of these entities that and recognize that in the statute. So that's a suggested technical amendment for your consideration. And then lastly, I just would note that, you know, for some of these department bills that we've talked about already previously, while this legislation wasn't introduced last session by the Bureau of Financial Institutions, it was something that they were working on, but didn't get to the committee before the end of the second session of the legislature last time. So you may consider adding an emergency preamble and emergency clause to the bill, so that if enacted, it would become effective once signed by the governor. And we don't yet have any fiscal information specifically to LD 224, but it's my understanding that these changes are minor, and any costs to the Bureau of Financial Institutions to implement the requirements can be absorbed within their existing budget.
Are there comments from the committee? Representative Evans, and you may need to turn off your video so that we can hear you.
Thank you, Madam Chair. Colleen, would you mind going back to your first slide where they were talking about holding at least one meeting in the state?
Yes.
Yeah, okay. And hold at least one meeting of its governing meetings in the state. Is there a time frame in there at all?
No, it's not. It would be, my understanding is there are requirements that there be annual meetings held by these entities. And so it would be, if there was only one meeting, if that was the case, then they would have to hold that meeting here in the state. But typically, my understanding is these governing boards might meet on a quarterly basis. So one of those meetings would be held in Maine and the other governing board meetings could be held outside of the state. It's an attempt, just to have more of a, based on the testimony from the Bureau of Financial Institutions, to have these entities have more ties to the state of Maine, since they're going to be organized under the laws of the state. The requirement that they not only hold one of their board meetings, there's additionally a requirement that they have its principal office in the state of Maine and have one of a resident of Maine be a member of their governing board.
Okay,
Thank
are
you.
there other comments or questions from the committee? All right, seeing none, and in the interest of time, I am just going to make a motion ought to pass as amended with the technical amendment and the emergency preamble that were suggested by our analyst. Is there a second for the motion?
Second.
Representative Morris is seconded. And is there any further discussion of the bill? All right, seeing none, I will ask Christian to call the roll.
Motion is ought to pass on amended. On LD 224, Representative Quint.
Yes.
Representative Quint ought to pass as amended. Representative Connor.
Yes.
Representative Connor ought to pass as amended. Representative Blyer.
Yes.
Representative Blyer ought to pass as amended. Representative Morris.
Yes.
Representative Morris ought to pass as amended. Representative Matheson.
Yes.
Representative Matheson ought to pass as amended. Representative Evans.
Yes.
Representative Evans ought to pass as amended. Representative Arford.
Yes.
Representative Arford ought to pass as amended. Representative Melorano.
Yes.
Representative Melorano ought to pass as amended. Representative Brooks.
Yes.
Representative Brooks ought to pass as amended. Senator Stewart is absent. Senator Brenner.
Yes.
Senator Brenner ought to pass as amended. Representative Tepler.
Yes.
Representative Tepler ought to pass as amended. Senator Sanborn.
Yes.
Senator Sanborn ought to pass as amended.
All right, so with that, we have concluded our agenda of work for this afternoon. Colleen, do we have any announcements that we need from you?
Not, I think, to the full committee, but at some point I'd like to touch base about scheduling for next week.
Oh, right.
With
Okay.
you and Representative Tepler, either today or tomorrow
Okay.
morning before noon. So that's it.
Okay, we can do that. Are there any other comments? Okay, seeing